So we're not doing good combination.
Caldwell versus Jack Brown. Sampson.
That you want.
Are you Jack Brown?
Yes, sir.
Good morning.
Morning.
This is 26 CR 0018. Mr. Brown, were you born in 1992? Last four digits, social security number 4108.
Yes.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Is essentially correct?
Yes.
Is there any reason why the gentleman should not be sentenced?
No, Judge, and I just wanted to make an argument for probation for Mr. Brown. He was given a pretrial diversion. It was set aside at our last motion day after I guess, getting off to a pretty bumpy start with his supervision. I think this jail time has opened his eyes a little bit. I think Mr. Brown is fully capable of being supervised, and I'd like to see the court give him another chance at that.
Commonwealth would oppose probation, but I'd be glad to look at it on the shop.
I think that's what we'll do. You had 3 years imprisonment, pretrial diverted on July 9th. That was voided. You had a pre-sentence investigation report done. We'll sentence you to 3 years. And the time will start counting now and taking a look at shock probation. I want to particularly emphasize any employability that he has and what his placement is going to be when he gets out and what sort of continued treatment that he might. Great. Thank you very much. Casey Fortin. Commonwealth versus Casey Fortin, 26 CR 0024. Are you Casey Fortin?
Yes, sir.
Good morning. Were you born in 1991?
Yes, sir.
Last four digits, social security number 7645.
Yes, sir.
You're here on a pretrial diversion revocation. You step to your left a little bit, Mr. Stockton, to your left.
So,
Yeah, your other left.
now, this case, Mr. Fortin's on, pretrial diversion, possession of controlled substance, 3 years. We had a hearing last month where he drove to the probation parole office, and then there was an altercation. He made some statements he probably shouldn't have made. And you suggested that he be lined up for anger management before he gets out, and that's kind of where we are.
And Judge, I had asked my social worker in my office to get involved, and she did. And Ms. Walker met with Mr. Fortin, and I think there was an insurance problem as far as getting this actual assessment done because he lost his insurance when he lost his employment. He's fully willing to do that. I would ask the court to consider, he's been in about 60 days. I would ask the court to consider that sanction with, and allow him to go back out on probation with the extra condition of getting that assessment.
If he is released, I need to know where he's gonna live. The home placement he was living at before he was lodged has guns in the home, and he needs to find a place that does not have guns.
I'll be living right across the street, sir.
Probation, my son, right, you know, where you're off.
In Monticello?
Yes, sir.
Yeah.
How do you feel about it?
The only issue I had is he looked at me and said he's gonna be, his mommy and daddy can't drive him everywhere. And he's gonna drive whether he has a license or not.
Well, now I don't have a car, so
Well, okay, you still got a little attitude.
I'm not trying to.
Well, I know, but you still got it. You give that sense out there, whether you mean to or not. The question was not whether you would drive. He said, will you drive or not? You said you didn't have a car. Does that mean if you did have a car, you would drive?
If I had to.
Well, then you're not gonna get out.
Casey, Judge, Casey's a good worker, and he finds himself in a tough spot because he's gotten in this situation in district court with license suspensions where he doesn't have a license, and he's got places that he has to be.
I'm wanting to work with him, but I can't let anybody out that says they're gonna drive if they have to. I just can't do
but
that.
part
So
of-
you need to talk to him. We'll take a look at it again next month.
Judge, part of the reason he's planning to live in Monticello is so he won't have to worry about driving to
Well,
probation.
yeah, well, why didn't somebody tell me that story then instead of saying this? So I'll bring it back up a little later. Go back and talk to him and get his story straight. Let's get a plan. I want to give anybody that's trying to work a break, you're an odd person that wants to work around here. You know what I mean? And I appreciate that. So get back and give me a story about how we're going to do this and we'll reevaluate. Okay, Christopher Guffey. Christopher Guffey. Commonwealth versus Christopher Guffey, 24 CR 0072. Are you Christopher Guffey? You born in 1976? Last four digits, of social security number 5843.
Yes, sir.
We're here on a shock probation revocation. What does the Commonwealth have? So you step to your left a little bit, sir.
It's a 3-year sentence.
Yeah, Your Honor, Mr. Guffey has a 3-year sentence on possession. This is a motion to revoke shock probation on 7/11/26. He bought tannerite and 30-06 ammunition, tannerite's an explosive. Admitted to being with convicted felons and then tested positive for admitted use of meth on the same day. So I'm asking that it be revoked.
You know, stipulate or you want to hear?
Judge, we don't disagree with any of those. He admitted, he
So you
freely
stipulate
admitted.
to those facts.
Yes, although I would note that in the probation and parole report, he spoke to the law enforcement officer, saw him at this shop buying the things. That's how it came to their attention. And he says, he had some rodents in his backyard that was giving him some problem, and that was,
So he's gonna
That was the
blow them
reason.
up.
that was the reason that he was doing that. So I would ask the court, despite the stipulation, to consider a sanction. I think he's still fully capable of being supervised. Obviously, he now knows he's not the person that
What
needs
all
to
did
be.
he have?
He had tannerite, which is an explosive.
Yeah.
My brother-in-law, I've seen been out with him, sometimes you shoot it, once it rolled up in the air. And he had about 30-06 ammunition and he used meth the same day. And that's what bothers
Kind of an
me.
odd combination.
It's not-
So if you got the ammunition, you probably got a weapon you're gonna put it in.
I'm saying.
Well,
And, would the court, in addition to a sanction, consider rehabilitation in-house or drug court?
look, in the world I live in, if somebody is not supposed to have a weapon and they're buying high-grade ammunition and explosives, it throws a flag up a little bit. So I'm gonna revoke the shock. Thank you very much. Anthony Richardson. Commonwealth versus Anthony Richardson. Are you Anthony Richardson? Good morning. You born in 1998?
Yes, sir.
Last four digits, social security 1777.
Yes, sir.
We're on probation revocation. What, you step to your left a little bit? Yeah, what's the Commonwealth have to say?
The allegations are, Your Honor, that he was administratively discharged from drug court because he was having seizures. Since he's been placed on probation and parole, he admitted to meth use on 5/11/26, 6/10/26. He admitted meth use. He would not attend SAP IOP like he's supposed to, and he was arrested for speeding, which is concerning to me. If he's having seizures, you know, he's supposed to be driving for 90 days every time you have a seizure. So he's just absolutely done everything he shouldn't be doing since he's been out on probation.
Your Honor, I have a potential conflict with Mr. Richardson, and he and I need to step back here and talk about that and see if I can stay in this, and I'll be right back out if that's all right.
Oh, okay.
Yes.
James Shelton. Commonwealth versus James Shelton, 25 CR 0097. Are you James Shelton? Good morning. Were you born in 1963?
Yes, sir.
Last four digits, social security number 8382.
Yes, sir.
Here for a pretrial conference. What do we have here?
Need a trial date.
What charge are you gonna let the attorney?
Well, they think it's best against the rape allegation. Down here a little bit.
Okay. Yeah, is there any witnesses you need to have here? Is there any forensic evidence?
Everything's been done, furnished all the evidence, get the ready, flow the witnesses. I'm gonna ask to go out and pass it to the person said that you do.
Would the third be too soon?
Probably would.
Okay.
So I'll talk to the car. I'm thinking sometime in the middle of September was the third.
You've got Commonwealth versus Eves in Cumberland County on the 22nd. You think
This.
you think that will go?
I don't think so. Let's just say this on the same day.
That gives us the ability to make a decision on it.
It's 21st. Tuesday, though. Yeah. Okay. The next, there's a rule day on the 10th. Do you have any motions to file? Okay. You got a couple of people in custody that are taking a second look at it, I guess. So we'll get to Billy Brown. Billy Brown. For Raymond. Are you Billy Brown?
Yes.
Good morning. This is 26CR 00060. Mr. Brown, were you born in 2003?
Yes.
Last four digits. Last four digits of social security number 0.
Yeah.
The grand jury of Clinton County has charged you with 2 counts of criminal mischief. Theft by unlawful taking over 1,000 with less than 10,000. And leaving the scene of an accident for failure to render assistance. You understand what those charges are? You understand what those charges are?
Yeah.
Okay. You acknowledge the identity of your client, counsel received indictment, waive formal reading and arraignment, interpleading not guilty, reserving all pre-trial motions.
Yes, Your Honor.
I'm signing reciprocal discovery orders so the Commonwealth to give your information to your attorney to help prepare your defense. What's the negotiation date?
August 28th at 9 a.m. Your Honor.
August 28th at 9 a.m. You're to be here for negotiations. And September 10th is your next court date. Both of them conditions of your bond, okay? Brett Carver for Raymond. Commonwealth versus Brett Carver 26 CR 0064, you are Brett Carver.
Yes, sir.
Born in 1976.
Yes, sir.
Last four digits, social security number 5893.
Yes, sir.
Your attorney had said he was in the hospital and wanted to appear by Zoom, but I don't see him on
He
here.
never reached out to me for this.
I just got a text from 901 that said he was trying to get on and couldn't. His stuff was down or something.
You're gonna have somebody stand in for arraignment for him and set it for the 28th. Because I've got to get the KSP still not assigned anybody for the
Okay,
case.
let me see if I can get Mr. George on the phone.
Okay.
Your call has been forwarded to voicemail.
Would you stand in just for the purpose of arraigning the counsel? Just for the purpose of arraigning, this lawyer's gonna say that. And granted, you are Eric Carver, you were born in 1976, the last four digits of social security number are 5893.
It was Brett, so
Is that correct?
you said Eric Carver.
Brett Carver, yeah. You said Eric, Brett Carver. 407-06-5893. There are 5 counts of second degree forgery. Do you acknowledge the identity of Mr. Carver?
That's right.
Yeah, and also falsifying business records, 115. You acknowledge the receipt of the indictment, waive formal reading and arraignment on behalf of Mr. George, interplea of not guilty, reserving all pretrial motions.
Yes, Judge.
I'm going to allow Mr. Carver to remain out on the same line. He's got the copy of the indictment, so I'll depend upon him to deliver that to Mr. George, and you're relieved of any further responsibility. You have on August the 28th, you'll have a negotiation day here, and the next court date would be September 10th. Okay, thank you. I guess there's a reciprocal discovery order coming on that here. Something, y'all got a reciprocal discovery order on that? Whitney Claiborne. Whitney Claiborne. Expungement hearing, is there any objection? There's no objection, the expungement order will be entered, okay?
All right, thank you.
Jason Coleman. Commonwealth versus Jason Coleman, 26 CR 0058. Are you Jason Coleman?
Yes, sir.
Born in 1977. Last four digits, social security number 4073.
Yes, sir.
It's, you file an affidavit for a public advocate. How long has it been since you worked?
About 3 months. Hold on,
Why aren't you?
my license,
What?
my license was suspended. I'm getting it back. In the process of trying to get it back.
Okay, well, I'll go ahead and appoint a public advocate. And reserve on whether or not you get charged something for it. Okay, you have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with driving on suspended operator's license. possession of drug paraphernalia, possession of controlled substance in the first degree, operating motor vehicle under the influence. You understand what those charges are? You acknowledge the identity of your client receiving that in a way, form, or reading, or interpreting not guilty, reserving all pretrial motions.
Yes, Judge.
Sign a reciprocal discovery order here. Client, Commonwealth will provide you with information to help prepare for your defense. August 28th, 9 a.m. here for a negotiation day. September the 10th is your next court date. Are you, Jay, are you drinking now?
No, I just haven't slept much last night because of this.
Yeah, you need to be careful.
I'll do it. Promise you, I'll take a break.
Okay. Luther Connor. Commonwealth versus Luther Connor, 26 CI 0001. Are you Luther Connor,
Yes, sir.
born in 1977?
Yes, sir.
Last four digits, social security number 5220.
Yeah.
You're here for pretrial conference.
You're waiting trial date.
What's the charge?
Strangulation and assault.
Judge, we're still doing some investigation. In fact, we're actually doing some today. So I would ask for a little time to go probably beyond where we set that Shelton case.
I really don't like these cases that involve endangering someone or assaulting who can put off for that long. You want it sometime in September.
And that would,
I understand the first part would be tough.
yeah.
Judge, what about the 29th? That's the following week from where we set the last one.
I'll be out of
I don't think there's been any allegation of any bond, any problems on bond or anything since he's been out.
What about September the 7th? What date is that? Okay. Good Hills Festival is on the 16th, right? Yeah, well, we're down to October.
16th.
Oh, we play at Clinton County on the Foothills Festival Day. Green County does.
Well, I got on the 14th.
So, do we see?
That's,
Involves, I think, 3 or 4 different cases.
yeah, that's right. How about the October 21st?
It's fine, later. 21st.
October 21st.
John Diamond. John Diamond.
Your Honor, that's our motion to extend this probation proceeding, especially the court, it's gonna run out before. Did you not get notice of it? We can re-notice it. Mr. Kraus said he didn't, we probably didn't list him as an attorney of record. Don't put something out. What?
When does it run out?
September, I think.
So what you want to do is extend the term.
He's got probation. I'll send Mr. Cross and re-go.
I'm sure it doesn't run out before the next month. I'll take this under advisement.
Okay.
Commonwealth versus Dickens.
Sometime.
Two.
Still, supposed to be 2 years. This is the
How do you say your first name?
Shakisha.
Yeah.
Keisha for short, Your Honor.
Shakisha Dickens, 24 CR 0052, 24 CR 007, born in 1979.
Yes, Your Honor.
Last four digits, social security number 3253.
This is the minute president of discharge from the court with the health reasons. So I'm asking that you be placed on supervised probation and remain to probationary.
No objection.
Hey, in order, you need to meet the probation parole.
Judge, she needs to understand that while on active probation, she will have to provide drug tests.
You need to talk to him. Step over there and talk to him. Brian Gross. Commonwealth versus Brian Gross, 24
Yep.
CR 0058 and 24 CR 0031. You are Brian Gross.
Yes, sir.
Good morning. Born in 1985.
Yes, sir.
Last four digits, social security number 2218.
Yes, sir.
It's a motion for release from supervision and motion from release from supervision. What do you have?
Judge, Mr. Gross has had a couple cases with the court, 24 CR, and of course, these were before I came back, so I'm gonna do.
58 and 31.
And 31, as my understanding, went to trial. There was a verdict of 3 years. He did some portion of 3 years, was released either on parole or MRS and has since served out that sentence. The plea bargain reached and 24 CR 58 ran that sentence, which was a misdemeanor, ran that sentence concurrent with the sentence in 24 CR 31. Therefore, he has served out 24 CR 31. He hasn't done anything to get revoked as of yet, but if he did, he would have it served out. There's nothing for him to serve.
Nothing on the shelf, you're saying.
Right.
Do you agree with that?
I agree. I don't have any objection.
Okay, in an order.
Thank you, sir.
Just be careful.
Yes, sir.
Okay, good
Do I
luck.
need to spend an order, Judge?
Yes.
Okay.
Todd Hall.
Robert, yeah, Philip Pickett, Mr. Porter.
Samuel Porter. Todd Hall. Commonwealth versus Todd Hall, 26 CR 0014. You are Todd Hall,
Yes, sir.
born in 1974.
Yes, sir.
Last four digits, social security number 7700.
Yes.
You're Samuel Porter.
Yes, sir.
This is 26 CR 0015. Mr. Porter was born in 1963. Last four digits, social security number 8494. Co-defendants. You have a waiver of your representation?
Yes, that's already been done.
Both of you understand that you signed a waiver and you don't object to Mr. Cross representing both of you, even though there might ultimately be a conflict. If there is, you'll have to. What's the combo of them? So y'all move over here. Y'all move on over here.
Your Honor, I'm a victim on this case, received additional evidence. There's additional charges against Mr. Porter going to the grand jury today. Once that's taken care of, if he's arraigned next month, then we can get a pretrial, one more pretrial, and if we can't resolve the case, then I'll.
Well, let's go ahead and put a negotiation day next month and you hand the information to him when it comes out today. Now, since he's already before the court, I'll have a summons issued instead of an additional warrant.
It's fine, sir.
That way you don't get arrested. September the 10th would be negotiation day. And
August 28th.
August the 28th is the negotiation day. September
I
10th. the next
know
court
I'll be out the 28th, but I'll make arrangements with Mr. Stockton to meet with him prior to
day.
that
Make sure
day.
they're there.
Yeah, we will, and we need to meet late on this one.
Great.
Okay, Your Honor, I note that Mr. Porter has got another indictment for another possession of firearm or convicted felon. If that should be processed as a summons and keep the same bond.
Are you talking about the one that's going in front of the grand jury
Yes.
today? How would you know about that?
Because Mr. Stockton and I have talked about it.
Okay, I don't know. What, Mr. Stockton, come on, you move over this way. Tell me about the firearm situation.
You've got the underlying case where Mr. Porter is accused of discharging a firearm near Mr. Doty, which caused injuries to his ear. And Mr. Porter denies having a gun and everything, so Mr. Doty furnished me proof before they were out target shooting. And Mr. Porter was firing with like a, I don't know, 38 or 45 caliber pistol. So, that's what we have. I think it's 45, Mr. Doty told me. So we're going back to the grand jury and indicting based on those videos, him firing the weapon, him being a convicted felon here in Clinton County. And then I want to decide which of these cases I want to try. I probably have to give 404B notice on one of them.
That's correct, Your Honor.
You know how I feel about firearms.
Well, I know, Your Honor.
That's the reason I'll go ahead and have him arrested. We'll take a look at this thing. So he can just be prepared to turn himself in. Couple things I don't tolerate. It's this firearms thing. But I'll take a look at it and have him evaluated by the pretrial.
I know he has very, very substantial bond already posted.
Well, I'll take a look at that.
Thank you.
Christopher Hayes, Mr. Raymond. Ain't been indicted yet. Susie's indicted. Are you Christopher Hayes?
Yes, sir.
Good morning.
Good morning.
This is 21 CR 0002. Mr. Hayes, were you born in 1992?
Yes, sir.
Last four digits of social security number 3119. You're
Yes,
here
sir.
today for the purpose of writing. If you have an attorney with you,
No, sir.
can you afford an attorney?
Yes, sir.
You can. Well, I'm just gonna go ahead and have the public defender step in for the purpose of arraignment.
I was sent there by Mr. Richard Armstrong.
I'm gonna arraign you here and then you can
Okay.
say what you want to say after you talk to an attorney.
Thank you.
The grand jury of Clinton County has returned an indictment charging you with receiving stolen property. You understand what the
Yes, sir.
charge is? You acknowledge the identity of your client for the purpose of arraignment. Receive an indictment, waive formal reading arraignment, enter plea of not guilty.
Yes, Judge.
Okay. Now, this gentleman has approached my staff lawyer earlier saying that,
Pretrial. It's pretrial.
or excuse me, pretrial saying something about the involvement of a former county judge. And I don't know anything about that.
Okay.
I don't know anything about it, and I don't want you to say anything else about it because it might incriminate you.
Okay.
Now,
Well, he's reached out to me too, and I'd like Mr. Hayes made a bond, and I need to go back and review the file and see if you got a legitimate defense, and then we can work through this.
Okay,
That's good the way it's
negotiation day on August 28th, be here at 9 a.m. Okay. And the next court date is September 10th.
So are we appointed on this?
Well, not,
Judge?
no, he said he said he could afford a lawyer.
Okay.
Right.
Okay, so you just give him the indictment and you're relieved of any further responsibility. You have a lawyer with you or here and be here on the 28th of August for negotiations. Okay.
Okay. Thank you.
Yeah. Daryl Halsenbeck.
My understanding, Your Honor, he's in custody in Alabama and we're working on that and getting him up there.
This show was finished though. Hey, you put a NCIC or warrant out for Mr. Halsenbeck.
Yeah, we've
Tyler
already.
Ledbetter. Tyler Ledbetter. Are you Tyler Ledbetter? Yeah. Good morning. This is 26CR0049. Mr. Ledbetter, were you born in 1991?
Yeah.
Last four digits, so student 8511. This is a pre-trial conference.
Judge, Mr. Ledbetter has a co-defendant, Terry Brett, who you'll see later in the docket. I've submitted a conflict request with Mr. Ledbetter. I kept Mr. Brett because he was in custody. And as of today, I know we've tried, we don't have anybody, and they're probably gonna have to go through the process of getting another DPA office, I guess, on this. I don't know.
What's the charge?
Theft by unlawful taking. Allegedly, he and Mr. Brett took over $60,000 worth of stuff from the Kraus Industries. So I know this case has been lingering for a few months. I hope the EPA will give it some priority so we can move the case.
I don't really know what to do. It's not your fault.
No, I'm not fussing on Mr.
I
Brett's
know,
case.
I know, but I'm just saying, I don't know what to do. I mean,
Well, we've managed to find something for everybody else. I think we'll
have somebody there with him on negotiation day on the 28th of August here at 9 a.m. But before then, you make sure you give him a good phone number that a new lawyer can get a hold of you and help you prepare for your defense, okay? September 10th is your trial date. August 28th is a negotiation date. Both of those are conditioned to your bond.
phone number still signed is what you get. Okay.
Do you have a cell phone?
Yeah, he's already provided us with
Okay.
a number.
Okay, thank you very much. Michael McLaughlin,
We'll have to put them in CIC, Your Honor.
Teresa Miller. For sentencing.
Judge, Bosie gave me some paperwork that was faxed to the clerk's office, I guess yesterday afternoon. She is in the hospital in Richmond. She's actually in rehab in Richmond pursuant to the conditions of her probation in this plea. And apparently fell ill and is currently hospitalized. And they faxed it again to the clerk's office.
Give it to the common attorney.
I've shown it.
Yes, Your Honor, looks authentic.
You just want to reschedule sentencing for next month, and
Yes, sir.
That'd be fine.
great. Sentencing for September 10th. Hannah Murphy. Was the expungement here.
No objection.
No objection. There, expungement here. Kyle Norris. Como versus Kyle Norris. 26CR004, 25CR0017. Are you Kyle Norris?
Yes.
Good morning. Were you born in 1988? Last four digits, social security number 9777. You're on a pretrial conference. What's the comment that was said?
We have a plea, Your Honor, pre-trial diversion.
Motion has been filed that says you want to enter a plea today. Is that correct? Yes. Are you currently under the influence of drugs or alcohol? No. Just plead freely and voluntarily given. Are you the same person that was named in 26CR004 and 25CR00117? Yes. Is your judgment impaired today? No. Can we discuss this matter with the attorney and satisfied with his advice? Yes. Read the evidence the Commonwealth has against you and you're fully informed about your case. You understand that you do not have to enter a guilty plea, that you have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I know that you need to know you understand those rights. I'll go over them and I'll ask you to understand.
Yes.
You have a right not to testify against yourself, no one can say anything, right to speak, trial, jury, right to be represented by counsel at your trial. Right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor. Right to appeal this matter at higher court if you lose, and right to fire the Commonwealth prove the unreasonable doubt. Various charges against you, understand that making them guilty plea that they would do a closure. Now, may I consider Commonwealth's recommendation, but also applying range by the law. In the event that I don't accept the recommendation, and decide to impose a harsher sentence, you're right to withdraw your plea guilty to the trial. Now, I'm going to ask you some follow-up questions on the diversion. Have you previously been diverted in the last 5 years?
No,
Have you had any felony convictions the past 10 years?
no,
Are you on probation now?
no,
You understand that if you fully complete the diversion agreement, your charges could be dismissed pre-trial and you have your record expunged. You understand that? You say if you don't successfully complete the program, I brought back in front of me for violation, we would schedule a sentencing hearing. And you'd be a convicted felon, and that could be used against you in the future to enhance sentences. You understand that? Step to your left, please. Mr. Stockton. What do you have?
In indictment number 26 CR 4, he'll plead guilty to theft by unlawful taking over $1,000, receive a sentence of 5 years. In 25 CR 117, he'll plead guilty to charge of wanton endangerment first degree, receive a sentence of 2 years. They'll run consecutive for a total of 7 years. That 7 years shall be pre-trial diverted for 5 years supervised. He'll pay restitution in the full amount of $6,500 plus the 5% clerk's fee from the bond money in the above style case. Be released to the victim. There's a restitution order that'll be accompanying the plea. He'll have no contact with the victim or their property. He'll receive credit for time served. My understanding is he's got quite a bit of time, home incarceration. He'll get credit for that. He will obtain and maintain gainful employment or do community service, and he'll also pay court costs at discretion of the court.
Who is the cash bond in this case?
Yes. My understanding is in somebody else's name, but he's going to obtain an assignment, have it released to the victim.
For the restitution, I'm gonna do that as soon as I leave here.
Is that what you agreed to?
Yes.
Are you pleading guilty because you did commit the act charged in the indictment as amended?
Yes.
You doing so of your own free will? Or your constitutional rights to still your desire to proceed and allow the court to fix your punishment? Is that your signature on the document?
Yes.
I accept the agreement, sign it. You need to meet with probation and told folks to get information. Okay?
Judge, because this diversion case is over, can I submit an order to terminate my representation?
I want you, yeah. Tiffany Perkins. Commonwealth versus Tiffany Perkins, 26 CR 0050. Are you Tiffany Perkins?
Yes,
Let her behind the microphone there. You born in 1987?
yes, sir.
Last 4 digits, social security number 8629.
Yes, sir.
You're here for sentencing today. You get an opportunity to look at the pre-sentence investigation board probation parole. It's substantially correct.
Yes.
Okay, you're sentenced to 5 years imprisonment, serve 82 days, obeyed 5 years. The 82 days and the 4 days shall run concurrently for a total of 82 days. How many days does she have in now?
Well, they're giving her credit for 72. I don't think there was any requirement to serve any additional time.
No, there's no additional date.
That's what I was making sure of. So
Yeah.
she needs to meet with a probation and parole officer. What was the court process today?
What's the fine?
I don't know. I'm just asking.
$840.
Total?
Yeah.
Okay. Does the agreement say when she's gonna pay that or how she's gonna pay it? You realize that the DUIs are enhanceable,
Yes.
correct? Okay. Can you pay $100 a month?
Yes,
Okay, you just make the first payment 30 days from today and $100 every 30 days to pay the full. You need to meet with probation and parole officer. Travis Powell. Commonwealth versus Travis Powell, 26 CR 0021. Are you Travis Powell? Good morning. You born in 1989?
yes, sir.
First 4 digits, social security number 7328.
Yes, sir.
Hey, what do we have here?
We have a felony plea for court to consider.
just been informed that a motion's been tendered that says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 26CR0021? Is your judgment impaired today in any way? It's voice activated. You need to speak
No,
up.
I'm not.
Okay.
No, it's not.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
You believe you're fully informed about the case?
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights in the Kentucky United States Constitution. Before I accept the plea, I need to know you understand those rights. I'm gonna go over them with you. Anytime you need to ask the question, your attorney step forward. If not, I'll ask you to end if you understand. Okay? You have a right not to testify against yourself. No one who makes the same thing, right to speak trial for jury, the right to be represented by counsel at your jury trial, the right to confront and prosecute all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in favor, the right to kill this matter, the right to require the Commonwealth to be on a reasonable doubt that you guilty of charge against you. Understand that you will give up all those rights. You understand that?
Yes, sir.
Now, may consider the Commonwealth's recommendation that it may apply to range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will wait pre-sentence investigation report to probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea or proceed to trial. What is the Commonwealth's recommendation?
Your Honor, Mr. Powell would plead guilty to possession of a handgun, a convicted felon, receive a sentence of 7 years, serve 10 consecutive weekends in jail, beginning August the 7th, from Friday at 6 p.m. to Sunday at 6 p.m. He'll report back to jail each and every weekend thereafter until he completes the 10 weekends or 20 days in jail. He shall forfeit the 9mm Taurus pistol. He'll receive credit for time served. He'll maintain gainful employment or do community service and pay court costs discretion of the court.
Is that what you agreed to?
Yes, sir.
Pleading guilty because you did commit the act charged in the indictment, correct?
Do what?
You are pleading guilty because you did commit the act charged in the indictment.
Yes, sir.
Okay, do so your own free will. When your constitutional rights, it's to your desire, you have those rights, enter plea and allow the court to get your punishment. Okay, you understand that by entering a plea, future convictions of felons can be enhanced.
Yes,
You
sir.
understand that?
Yes, sir.
Okay, is that your signature on the document?
Yes, sir.
Okay, now I'll need a pre-sentence investigation report to be done by probation and parole. We'll schedule the sentencing for September the 10th. Okay. You need probation and parole officer. Jason Savage. Jason Savage. Commonwealth versus Jason Savage. 26CR0028, Jason Savage. 1981. Last 4 digits, social security, 3224. Here, Representative Ms. Ayers. What's the comment have to say in this case? You'll move to the left here.
Discuss this case with his attorney, Your Honor, and if we could have one more, let's talk about it. We'll simply resolve this case.
You want a negotiation date too? Negotiation date on August 28th at 9 a.m. The next court date on September the 10th. Okay.
Thank you, Your Honor.
Okay, thank you.
Have a good day.
Thank you. Please be safe traveling.
Thank you.
Commonwealth versus Jada Shelton. Jada Shelton.
That's for the race warrant, Your Honor.
FDA. Nathan Stockton.
I don't know if he knew to be here or not. Was there a summons or anything done? He's, and was he DPA representative in the trial last time?
There were 2 cases, Judge. We went to trial on one, we continue the other 2 of the years, not. We're making this, I think this is trying to get the other 2,000 track. So we might.
Issue a summons from it appeared to next rule date. September 10th. Mitchell Thrasher. Commonwealth versus Mitchell Thrasher. 25 CR 084. and 26 CR 0055. Are you Mitchell Thrasher? Good morning. Were you born in 1964? Last four digits, social security number is 3055. Your pretrial conference.
Yes, sir.
What we have?
We have a felony plea for the court to consider.
Do you need a hearing device? Can you hear okay?
Yeah, I can hear, okay.
The grand jury of Clinton County has returned an indictment against you. A motion's been tendered that says you wish to enter guilty plea today. Are you currently under the influence of drugs or alcohol?
Is there?
Or is this plea freely and voluntarily given? Is the plea freely and voluntary? Are you the same person that we just named in 25 CR 0084 and 26 CR 055? Is that
Yes,
you?
sir.
Same person?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you? Believe you're fully informed about your case?
Yes.
Understand that you do not have to enter guilty plea. You have certain rights under the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm gonna go over them and see if you understand. You have a right not to testify against yourself. No one can make the same thing, right to speak trial by jury.
Yes, sir.
Your right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, right to part of the Commonwealth if you have reasonable doubts that your guilty charge against you. Understand by entering guilty plea that you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may claim or apply the range of sentence provided law. I don't have to accept it prior to accepting the recommendation. I will have a pre-sentence investigation report during the probation parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation?
Your Honor, in case number 25 CR 84, he'll be pleading guilty to possession of controlled substance first degree, receiving a sentence of 3 years. Also in 26 CR 55, he'll plead guilty to possession of controlled substance first degree, first offense. He received a sentence of 3 years. Those 3-year sentences shall run concurrently for a total of 3 years, probated for 5, supervised. He received credit for time served. All evidence in this case will be destroyed and will pay court cost discretion.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty? Because you committed the acts charged.
Yes, sir.
You say you're on free will. Knowing your constitutional rights explained is it still your desire to give up those rights and allow the future punishment within the range of sentence provided by law?
Yes.
You understand that enter guilty plea, your future conviction could be enhanced in the persistent felony offender law. You understand that?
Yes, sir.
That's your signature on there? I'll
Yes, sir.
accept the agreement. Order pre-sentence investigation report, schedule sentencing on September the 10th, to continue on the same bond. Be with probation parole officer over here. Show him for the probation parole officer. There it is. And I'll tell you what your court costs us if things are then when you come back for sentence.
Okay.
Naomi Tucker. Commonwealth versus Naomi Tucker, 26 CR 0035. Are you Naomi Tucker?
Yes, sir.
You're born in 1985.
Yes, sir.
Last four digits, social security number 5405.
Yes, sir.
Are you the pre-trial comment? What does the Commonwealth have to say?
Well, I believe we have a pre-trial diversion, believe you.
Okay. Understand that you had filed a motion. Is that correct, ma'am?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea free or voluntarily given?
Yes, sir.
Are you the same person in indictment number 26 CR 0035?
Yes, sir.
Is your judgment impaired in any way?
No, sir.
You discuss these charges with your attorney. Are you satisfied with this advice?
Yes, sir.
Review the evidence Commonwealth has against you. Believe you're fully informed about your case.
Yes, sir.
You understand that you do not have to go guilty, that you have certain rights so they can take the United States Constitution. Yeah, I'm gonna go over and then just don't step away and ask your attorney. You have a right not to testify against yourself. One to make the same right to speak trial by jury. You have to be represented by counsel at your jury trial, right to confront and talk to all witnesses called to testify against you, right to use evidence, right to call witnesses, right to well, matter how a court believes, and right to file a Commonwealth plea beyond a reasonable doubt, guilty charge. You understand that by entering a plea of guilty, they give up all his rights. You
Yes,
understand
sir.
that? Now, I consider Commonwealth's recommendation, but it may apply in range of sentence private law. I don't have to accept the recommendation. In the event I do not accept the Commonwealth's recommendation, and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial.
Yes, sir.
Okay, now I'm gonna ask some qualifying questions. Have you previously been diverted in the last 5 years? Been felonies in the last 10 years?
No, sir.
Are currently on probation?
No, sir.
You understand if you successfully complete the diversion program, the case will be dismissed pre-trial diversion. You have your record expunged. You understand
Yes, sir.
that? If you don't successfully complete the program, you'll be brought back in front of me. If I find that you are in violation, I will revoke the pre-trial diversion and you'll be sentenced, and then you'll be a convicted felon. You
Yes,
understand
sir.
that? Commonwealth's recommendation.
Your Honor, Mr. Tucker will plead guilty to terroristic threat in the second degree, receive a sentence of 3 years, pretrial diverted for 5 years supervised. She'll be referred to the SSC, follow all recommendations. She'll receive credit for time served, obtain and maintain gainful employment, do a minimum of 30 hours community service a week, and pay court costs discretionary authority.
Okay.
Is that what you agreed to?
Yes, Your Honor.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
So you're on free will.
Yes, sir.
The Constitutional rights explained it to you desire for proceeding your plea allowed in court to fix your punishment by law. Is that your signature on there?
Yes, sir.
Accept the sign the diversion order. What's the court cost of this?
$150.
Need some time to pay that?
Yes, sir. I'm in
Okay,
rehab.
pay it $30 a month, first payment being 30 days from today.
So it'd be the first day, like,
30 days from today.
okay, so I'm in rehab right now and I can't have
How long,
employment.
how long have you been?
I've been there 2 weeks
How
and
long are you gonna be there?
I'm not sure. It's a 28-day program, but depending on,
Well, they have you working or is it?
no, we're not allowed to work while we're there.
Okay, 30 days after you get out.
Okay.
Okay.
Okay, thank you, sir.
Christopher Wright, active worn out.
Yes, we'll put them in the action.
Okay. Let's go to CTS Russell. Is CTS Russell on there?
He's in case.
William Purdue. I see William Purdue up there. William Purdue, you turn your camera on.
Yes, sir.
This is
Can you hear me,
25.
sir?
Yes, I can. This is 25 CR 009. You are William Purdue. You were born in 1971, right?
Yes, sir.
Last 4 digits of 375, 71 is motion for shock probation. Proceed.
Judge,
Go ahead.
Willie was sentenced back in December of '05. I filed this motion a few months back. We've had trouble getting them on board with sending, but we got him today. You know, he's local roots. Willie has had his issues, been in and out, but he's got a good family, a good mom that not here, but she's been in plenty of contact with me. Now, Mr. Stockton did
What
tell
was he
me.
convicted of?
It's a possession case, 1 year, Your Honor. Not in this case is for Mr. Purdue's guy. It is in 15 CR3. He took 12 and a half years on manufacturing methamphetamine. After that, he had another 21 case. He's got about a total of 13 years on the shelf, and he's not eligible on the manufacturing case for shop. He's eligible on the possession case and maybe the 21 case. So even if you shot him, I don't know if he'd get out of jail. And I don't see why you would do that and separate the cases.
Judge, if that's correct, I mean, obviously the 15 case, the time has expired. There's no question about that. That was not my understanding when I filed this. My understanding is he was serving
Well, let
on.
me let you do some research and we'll continue to next month. I won't rule on it yet.
Okay, thank you,
If I'm
Judge.
there, I'll be, but Mr. Payne said it's still like.
Mr. Purdue, your attorney's gonna do some additional research to see if you're eligible on the older charge or not, and he'll be in contact with you, okay?
All right, thank you, sir.
Okay, the CTS Russell, y'all are excused. Thank you very much. Eastern Kentucky Correctional Complex. They're not on yet. So could somebody call them? You what?
They need to choose a payment.
I think we're gonna have to do transport order.
Okay, let's do a transport order for Mickey Shelton and Charlie York both, okay? Good deal. The next court day. Jackson County Detention Center down there. Jackson County, you're on there, don't appear to be on there. This is a probation revocation. Y'all are involved in public advocacy, involved in that too. Jackson County's usually been pretty good about participating.
Yeah, and I spoke to them earlier in the week and they were fully ready to. Now, they did tell me that they had court this morning. And I forget what county they said, and so they were going to perhaps get on a little bit later, but I thought by now they would have been on.
What do you want to do, Mr. Scott?
Well, if they don't get on, I guess we'll
Have you explored the track?
Just do a transport order. If they get on, we'll take it back up. So we won't lose it on the docket. Scheduling for next day. Russell County Detention Center. They're not on either. They're usually really good. Did somebody call Russell County Jail? Where's our?
I've seen it to make sense, you can get good, yes.
We'll come back to that. Clayton County Jail.
Or half an hour earlier, but she's got two transport.
Okay. Anthony Richardson. Yeah, we need. Anthony Richardson is the jailer back there?
Yeah.
It's 24 CR 0020. Previously took it up, you're still Anthony Richardson, correct? What you got?
Your Honor, we're prepared to stipulate on the revocation today.
Okay, what's the combo have to say?
I would ask that, Mr. Richardson be revoked, Your Honor.
Well, how much time does he have?
We've got 3 years on possession, please.
Okay, well, we'll enter the order. Good luck to you.
I'll be back today.
Okay, you know, we got Casey Fortin.
Stay out here.
Casey Fortin still back there. Okay, what do we got on Casey Fortin?
Judge, the plan for Casey is he's gonna be moving to Monticello within easy walking distance of the probation office. And the problem he had before, although he had a good job that he maintained for a good period of time, is it was in Somerset. And without a license, getting to Somerset,
I understand.
obviously a big problem. So he's gonna have to find employment local, more local than Somerset, and which will make transportation less of an issue for him. So I would ask the court to allow him back out on probation to continue reporting, and he can do the anger assessment when he's out, and he'll I'm sure he'll have employment within a few weeks or a month.
What do you want to do, Mr. Scott?
I don't mind letting him out, but I want this counseling set up quick. I think it needs to be reviewed in 30 days. And he needs some help about controlling his tempers.
Okay, I'll sign the order. Tell me, you need to be back here in court on September 10th, unless you've gotten into the anger management. If you've gotten into anger management, you need to inform your attorney and he can get a signed order and you'll be on your way. Probation parole officer needs to talk to you for a second, okay? Hey, just kind of calm down a little bit, and you gotta, you know, kind of a brute sort of guy, you know, so you gotta be careful what you say because people are gonna take you seriously, okay? Probation parole officer, right there. Okay. Russell County, you on there now? Let's go to Russell County. Commonwealth versus Spencer Althouse. Are you Spencer Althouse?
Yes.
This is 25 CR 00100 and 25 CR 00112. Mr. Althouse, were you born in 1989?
Yes.
Last four digits, social security number 8324.
Yes.
Okay, what does Commonwealth have in this case?
Your Honor, I had a meeting, we just got the DNA test results back in this case, and I had a meeting scheduled with the victim this coming Monday, but I'm not gonna be able to keep that now. So we just asked for one more negotiation and one more pre-trial conference.
Negotiation day would be on the 28th, is that correct? August the 28th, the next court date on September 10th. Your attorney will be over to speak to you, okay? So,
Okay.
thank you very much. Russell County, y'all have anybody else that needs us over there?
Not that we're aware of, Judge.
Thank you for your cooperation, y'all excused.
You too, sir.
Yeah, Clinton County Jail. Clinton County Jail. Clinton County Jail.
First September.
Yeah.
Logan Bell. Are you Logan Bell?
Yes, sir.
You here for the purpose of arraignment. This is 26 CR 0059. Mr. Bell, were you born in 1992?
Yes, sir.
Last four digits, social security number 8192.
Yes, sir.
You have a right to remain silent. The Office of Public Advocacy to represent you there here and present. The grand jury of Clinton County has returned an indictment charging you with criminal mischief first degree, possession of controlled substance first degree methamphetamine, assault in second degree, endangering a minor of welfare of a minor 2 counts, wanton endangerment in the first degree 3 counts. You understand what those charges are, correct? You understand the charges?
Yes.
You acknowledge, counsel, you acknowledge the identity of your client, receive indictment, wait formal reading and arraignment, you include not guilty, so now pre-trial motion.
Yes, Judge.
Signing a requirement for reciprocal discovery. We'll set August 28th for a negotiation day, and the next court date is September 10th.
Judge, what is his bond currently set at?
It's $20,000.
I would need a bond period in this bunch.
You can talk to Mr. Stockton about that.
Okay.
Thank you very much. Terry Britt, next is Terry Britt. Commonwealth versus Terry Britt, 26 CR 0048. Are you Terry Britt?
Yes, sir.
Were you born in 1995?
Yes, sir.
Four digits, social security number 7633.
Yes, sir.
Current pre-trial conference, what's the Commonwealth say?
Your Honor, this is the co-defendant that didn't have counsel, so we just need to pass them on that, so we keep them on the same note.
August the 28th, September 10th.
That's correct.
Okay. Your attorney will be over to talk to you, Mr. Britt.
Thank you, sir.
Tommy Claiborne.
Yes, sir.
Claiborne,
Yes, sir, I am, Your Honor.
morning, this is 24 CR 0057. Mr. Claiborne, you born in 1974.
Yes, sir.
Four digits, social security number 0040.
Yes, sir.
Okay, you're here on a probation revocation. What's the consequence?
Your Honor, Mr. Claiborne has a possession controlled substance first degree, 3 years. He on July 8th of 26, he admitted meth use on June 19th of 26, June 21st, 26, June 23rd, 26. He's also admitted to associate with a convicted felon. And according to Mr. Payne, when we discussed this case, he's got about over 400 days jail credit on this case. So I just asked him to be revoked this time, meet the parole.
I want to double check that to make sure, but I'm pretty sure that's right.
How close would he get to?
That's almost absurd that.
Yeah,
It would be close. I don't know how.
well, okay, if we revoked him, when would he, he's parole eligible?
He's parole eligible.
Well, I think that's what we just go ahead and do is just revoke it, and let him go to the parole board and get it behind him. Okay, counsel, does that seem reasonable to you?
It does. I know that he wanted to be given another chance on probation when I spoke with him yesterday.
Yeah.
But that is a significant amount of time.
He is, and parole, being in supervision parole board is not quite as difficult as probation and everything, so we'll do that, okay? Your attorney will go over and talk to you about it, Mr. Flavor.
All right, thank you, Your Honor.
Randall Hicks, Commonwealth versus Randall Hicks, 26 CR 0056 UR, Randall Hicks,
Yes, sir.
1973. Last four digits, social security number 2625. This is a motion to revoke bond and pretrial conference. What's the Commonwealth have to say?
Your Honor, we have another case working its way up in the system, it's going to the grand jury. So if we could pass this 1 month and get into negotiations.
Let's do a negotiation day for the 28th of this month and next court date's 10th next month. Mr. Hicks, they say that they've got another case that might be going to the grand jury, so to advance this some time for you, they'll have a negotiation day with that one and not have to wait another month, okay?
All right.
Okay, thank you very much. Edward, McGee here, how you say your last name, sir?
You're referring to Edward Wayne Minor?
Minor, okay. Edward Minor, 26 0057. Mr. Minor was born in 1959.
Correct.
Last four digits, social security number 6147. We're here on a pretrial conference. Where you at?
Your Honor, we have requested, defense counsel has requested ballistic testing on the gun to see if there was blood on the gun. And we sent that off for that. Also, we're waiting on medical records on the victim from Knoxville. So if we can just put this case out a couple of months, maybe we can give you a status report.
Yes, sir.
How about October 8th? And what will be your,
I believe it'll be September 25th, but I'll confirm that with Mr.
okay, September 25th negotiation day and October the 8th. So if you need him transported up here to the courthouse, you'll need to do it. I'll be in transportation.
It's not 28 for not 25 for negotiation, you said.
Right.
Okay, and
Next court date.
is October.
October
What is your very next court date, Judge? I'm scheduled for trial that I believe is going to go in Laurel County on October 8th. Is there a very next?
Well, we can bring him to some other county, or we can go out to November. Let's just wait and see what's developing on it. See if you have an agreement.
That'll sound good. Thank you very much, Judge.
Okay, have a safe trip.
Appreciate you, sir.
Yeah. Your attorney's gonna be down to talk to you. Kelvin Rodriguez. Kelvin Rodriguez.
Well, the interpreter is supposed to be down about 10:45.
Okay. The interpreter will be on at 10:45. Mr. Rodriguez, we'll be back. We'll be back to Mr. Rodriguez.
Yes, Rodriguez? Your Honor, we've got it settled, but the problem we've got is he speaks no English.
Well, that's the reason we said that the interpreter's supposed to be on at 10:45. Is that what you said?
That's what the message I got from Mr. York.
So what I'll have to do is I'll have to go down, if it's logistically, if we can do this, because he's in the jail, I've got to get her to go over the paperwork with he and I there.
She's only
Be a lot simpler.
gonna be on the Zoom before Mr. York, so that's the word.
Well, it might work if we brought, I don't know, it's logistically, it's tough. I'd like to get it done.
We established that we would all like to get it done.
We're gonna do it in Rowe County next week.
How would that help him if he doesn't have the interpreter?
Yeah, and he's still gonna have, he'd have to have him transported over there and the interpreter, that could be
Yeah, we're
there.
not-
His wife is fluent, but she's not here.
She's not certified to be.
Well, she could be certified
I
to
also
have
don't know if this interpreter
sign the documents.
is allowed.
We better just pass it.
Yeah,
Because
you
normally
have two
we need a
interpreters.
separate interpreter to go over the paperwork, but the court interpreter's not allowed to go.
Well, I can get everything signed before the next court date. We could do it in Cumberland County, that would be great.
We'll just do it here next month.
Well, kind of just delays him getting out, but
It does do that.
But he's got a revocation also, so.
Do what?
He's got a revocation also.
David,
and it's all tied in together.
David,
He's got a what?
Revocation.
Mr. Cross.
Why don't you go ahead and let him stipulate to the revocation that way?
I'm sorry.
Why don't you let him go ahead and stipulate the pretrial diversion? So it'll be fine.
Because I can't communicate with you.
We can't talk to him.
You don't have a translation on it?
I'm gonna put him on the calendar for September 10th. If y'all work something out before then and appear someplace else, I'll consider it. Okay. September 10th, thank you. Lucian Stevens. Lucian Stevens.
Just a second, Your Honor.
Is this the last one? Lucian Stevens, are you Lucian Stevens?
Yes, sir.
Good morning, this is 23CR0032 and 26CR0051. Mr. Stevens, you born in 1996,
Yes, sir.
4 digit social security number 5171.
Yes.
Okay, what does come up have to say?
We have a felony plea, Your Honor.
Okay. A motion's been tendered, sir, that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes, sir.
The same person named in indictment number 26CR0051 and previously on 23CR0032.
Yes.
Is your judgment impaired today in any way? Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you? You feel like you're fully informed about your case?
Yes.
You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go over those rights. If anytime you want to ask your attorney something, you step forward and poke. You have a right not to testify against yourself. No one can make you say anything. Right to speak, trial by jury, right to be represented by counsel at your jury trial. Right to confront, cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in favor. Right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. That you understand that by any guilty plea, they give up all of your rights. You understand that?
Yes.
Now, I consider the Commonwealth's recommendation, but I may apply and arrange a sentence provided the law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll wait to pre-sentence investigation forward. In the event I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea and go to trial. Do you understand that? Mr. Stockton, Commonwealth's recommendation. You step to the left, counsel, so you.
Yes, Mr. Stevens will plead guilty to wanton endangerment, first degree, receive a sentence of 2 years. He will also plead guilty operating a motor vehicle, first offense under the influence. He'll receive a $250 fine and 4 days in jail. He also plead guilty to failure to maintain insurance, will be a $500 fine and cost. He'll receive credit for time served. And I don't see it in here, but I thought he was stipulating to the revocation in his other case, which would be case number
23CR0032.
Yes, he stipulated the revocation in the case.
Is that what you agreed to, sir?
I didn't see
Thank
it.
you.
Is that what you agreed to?
Yes.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment and on the stipulated?
Yes.
Do so of your own free will.
Yes.
You doing so to allow the court to fix your punishment within arrangement of the law. Is that correct? That you understand after entering this plea, any future convictions to be enhanced with persistent felony offender law. Do you understand that?
Yes, sir.
Will you bring his signature up here and let me show it to him? Is that your signature on there, sir?
Yes.
Okay. I'll accept the agreement or pre-sentence investigation report and schedule sentencing on September the 10th.
He'll also need to be sentenced on his pretrial diversion that day.
On both those. So that's on 23CR 0032 and 26 CR 0051. So that you'll interview him on both of those, correct? Okay.
You're revoking his probation today,
Yes,
correct?
sir. Is there anyone else on the docket? Thank you very much. Your attorney, Lou, should be able to see. Is there anybody else there at jail? On the docket? Mr. Stockton, do you have anybody else?
I don't have anything else.
Well,
Oh, yeah, we have
Where we got to go.
Turn it off. I've got you flipped over one of the
Harden versus Harden.
That's one of these cows, that's.
Been a motion for a continuance. In this case, she asked for a date certain to continue. September 10th. It's continued September 10th, okay? Thank you very much. Cody Mitchell versus Samantha Mitchell, now woman.
Miss Bonner, who's on the other side, just need a request for the Zoom link, so it might take you just 1 second.
We'll have to come back to the case, okay? One of the attorneys is not on the Zoom link. Very complicated thing. Sarah Flowers versus Commonwealth Life Insurance Service. Well, I want to thank you all for taking up my evening last night. It was, except for my last reading of Gone with the Wind, it was like an hour's worth of all this thing, but it's pretty interesting. What do you have to say, Mr. Carroll?
Well, Your Honor, we have filed a motion, as you know, for a partial summary judgment. And I'll just quickly run through.
Let me do a little Socratic stuff to see if I understand. And y'all can chime in. Who do you represent?
Judge, I'm here to introduce them. I'm here on behalf of the defense, Transamerica. But I hear for local counsel for Marlon Leventhal, who is primary counsel for Transamerica.
And where are you from?
I'm from Washington and also
Washington, DC or state?
Washington, DC, yes.
Yeah, you do. The Lord's working at Devil City, I guess. Okay, well, let me see if I get this thing straight. I read all the things several times last night, and I'm not an expert in insurance policies for sure and for Medicare, but let me stop me anytime I'm wrong here. Let me get some certain facts around. Sarah Flowers and her then husband got a cancer insurance policy. All in agreement on that. They kept the policy in place and she got a diagnosis of cancer. At the time she bought the policy, or they bought the policy, there was Medicare A and Medicare B. Medicare C had not come online yet.
Or D.
Or D. Okay, is that correct at this point? Okay. So this policy, then when C and D came on board, the policy was never modified. Is that correct? She was already drawing benefits. That's what, was she already drawing benefits?
Yes.
So she got the cancer situation, and the drugs that were being provided were provided outside of the hospital setting under A and B, which are doctors and hospitals. Is that correct up to this point? For a series of years, significant payments were made to Sarah Flowers. And then at some juncture, a policy of the insurance company changed and reduced the benefits to about $200 copayment or something like that. There is a issue on what the level of benefit would have been, whether it was what I call the rack rate or what someone, an insurance company or Medicare would be paying. Is that correct? It's for
That is an affirmative defense that the defendant
right.
has.
Which that always bothers me anyway, when hospitals sue people to collect bills and they charge the rack rate. But if the insurance company or Medicare had been paying that and they'd had insurance, they've gotten a lesser amount. So you maintain that your client bought a coverage paid premiums for coverage and was entitled to that, and that the reduction could not take place for modification because what she was actually buying was insurance that would not be reduced by any Medicare payment, because the other part, benefits for payment, was not a Medicare payment, but a private insurance company that they got. Is that essentially?
That's a good portion of it, Judge.
Okay, now what would be the rest of it?
Well,
Is it C or D that was gonna do the?
D is the drug coverage.
Yeah.
C is another type of coverage you could buy that may or may not
Like
include.
when I got old enough for Medicare, they started calling me about.
Right. And call you every year.
Free groceries, we do this, free car washes, okay. Okay,
So it's basically D is
and how old is your client?
my client is 67, I believe.
So, okay. Now, tell me a little bit more before I let them tell me what the fallacy of this approach is.
Well,
There's two different issues, is what she would be entitled to if she's entitled to anything, whether it's like the rack rate or what would be really paid. And there was some issue of whether you could determine what Medicare would have paid, right?
that's correct, Your Honor. The case law which we have cited, including the Sixth Circuit and federal court case, says it's I guess what you're calling the rack rate, the billable amount,
Yeah.
is what the policy then has to pay.
Yeah.
The defendant has raised an issue, I think, of whether that exceeds the customary,
Yeah,
usual and customary charge, which is an affirmative defense under the policy.
right.
So I'm not asking for a summary judgment on their affirmative defense.
Yeah, I got you.
But
I'm just trying to understand the whole thing.
But the part, as far as interpretation of what I call the part of the policy that gives coverage, their terminology is ambiguous. If it's ambiguous, it's interpreted in favor of the insured.
Right.
And that's exactly what Judge McKinley held in the Pedicini case. And so that's one part that I'm asking for a summary judgment on. The other part.
Well, let's just deal with that part. Let's deal with one part at a time. Then we'll get to the other part.
All right.
What do you have to say? Which one of y'all gonna argue this? Welcome to our court.
Thank
Go
you.
ahead.
Thank you.
If you get behind the microphone, I can hear you a little bit better.
A couple things. First of all, the policy includes a definition of Medicare, and it's the statute as amended and as becomes effective. So the fact that Part D might have come in later.
You have to speak up a little bit.
I said that the policy had a definition of Medicare, and that definition includes Medicare as the statute is amended.
Okay, well, let me ask you about Part D. Part D is not paid for by federal funds, but is paid for by the recipient. Is that right?
I'm not sure about that.
Isn't that true? See, I mean, Part D is something that someone that a recipient can decide they want to buy. And they don't really buy it from Medicare. There are other private providers. So it's actually private insurance agencies or companies that sell Part D coverage because they compete with each other. Is that correct?
I don't know that that's correct, but we do have a Medicare expert looking at that. But my point would be that if the drug or medicine is payable under Medicare, whatever part, policy doesn't specify any parts, then it's not covered under the policy, regardless of whether the insured elects Medicare. And that's the situation we have here.
And if the insured does what?
Regardless of whether the insured elects Medicare.
Part D. Right.
Any part, right.
Well, you don't elect Part A or B, do you? Everybody has to, you have to have that or you get penalized. I don't know anybody that doesn't A. You know anybody that doesn't do A or B?
I think that the policy uses the word eligible. So.
You said elect. When you said elect, kind of threw me off a little bit.
Let me just check that.
Well,
I want to make sure.
When you get old enough to do it, you'll understand. When it comes time that you got to sign up for A and B, if you don't get A or B, they penalize you later when you come in if you don't do A or B. So it's not really an election. And then on D, when you come in, you get the choice of participating in that or not participating in D. And if you participate, then there are various providers that are approved to be Medicare D providers, and you choose one of those and they compete with each other in the marketplace.
Right, so in any event, there are no benefits payable for any charges payable under Medicare, regardless of whether the coverage is elected by the insured person. So whether she elected it or not, I don't think there's an issue in this case. It's clear that she did not elect.
Well, let me ask you, I understand what you're saying, but when this policy was bought and when the cancer was discovered and the payments were made, Part D didn't exist. Is that correct?
It did not exist till 2006,
Yeah, and she got the cancer diagnosis in
97.
97. So what you have is you have a insurance, I'm trying to understand this. You had an insurance benefit that significant payments were being made under the policy that was written. And then they come around and let Part D come in, and let's say this lady decides not to elect for Part D because it probably wouldn't have been a good election for her. And you're saying that the payments stop under the previous policy because Medicaid Part D was available to her. Is that what you're saying?
Yeah, I'm saying that if the charges were payable under Medicare, regardless of what part, as the statute is amended or becomes effective, those charges are not payable under this policy.
But Part D is discretionary. You don't have to participate in Part D, correct?
Correct. You don't have to participate in A or B either. You can keep private insurance if you want to. That's the whole point of that clause, regardless of whether the insured elects it or not. So it doesn't matter whether she elects it or not.
Even if she's paying the premium.
Well, she doesn't have to pay the
On
premium.
D, she does.
No, I thought you meant the policy.
No, I'm talking
premium.
about the D.
Right. It doesn't matter whether she elects it or not.
Well, who's paying the premium on D?
She doesn't, as far as I know, she has not elected Part D. Is that
Yeah.
correct?
That's correct.
She didn't, but who, if you have D, who pays the premium on D?
I believe she would have to pay the premium.
Well, so the choice that she has is if she's on this plan that's existed, she can either, if she decides to pay for Part D, then it immediately cuts off this benefit. Because you know, your position is, and it might be the correct position, your position is because D would pay for this, when she's not entitled to receive anything under the cancer payment. Or if she doesn't elect D, you're saying, well, she could have elected D and she doesn't get paid. So in other words, the policy or cancer policy, that premium that she paid for those years and those benefits has changed, you say, because the federal law changed. Is that what you're saying?
I'm saying that this policy doesn't pay benefits once you become eligible for Medicare. If the charges are payable under Medicare, and it doesn't matter whether you elect it or not, and it doesn't matter what part it's under.
So the change in the law, you know, severely limited any benefit that she was entitled to under this policy, is what you're saying.
The change in the
The
law.
change in the law, when they created Part D,
No,
they created Part D, and you're saying that whether she elects to be in Part D or not in Part D, she could receive benefit under Social Security. So her cancer policy has been diminished because of that. Is that what you're telling me?
I'm not saying that the change in law diminished her policy, because the policy again defined Medicare as amended or as it becomes effective
Well,
or as it's
okay, if her
changed.
policy is not changed, the benefits were diminished that she would be entitled to. That's what we're here about, is that she has diminished benefits. Previously, she was getting large payments, and then when the Part D came into effect, it's your position is that by operation of the terms of the contract, she wasn't entitled to that any longer. So
That's
y'all quit
correct.
paying it.
Let me hit another issue, because
ahead.
we're here on a summary judgment and there are other issues of fact, which are pretty big issues.
Okay.
First
I'm
of
just
all,
trying to understand the
Right.
policy. Go ahead, take
Um,
plenty of time.
first of all, so this policy provides extra money, essentially. It's a supplemental cancer expense policy. So all of Sarah Flower's medical expenses, the healthcare expenses, were paid by Anthem Blue Cross Blue Shield.
Right.
Okay, this policy and drugs and medicines are measured by the actual amounts the expenses incurred, pays extra money, which she can use for whatever purpose she wants. Right? The key language here is that the policy pays benefits for expenses incurred. And one of those types of expenses are drugs or medicines used in the treatment of cancer. Now, we've come to learn just through the discovery that apparently Sarah's cancer was cured long ago. And so as we sit here today, and for many years, she's been cancer-free. So the drugs and medicines that Mr. Carroll is trying to get summary judgment on, it's not even clear those are used for the treatment of cancer because she doesn't have cancer anymore. So that is a huge factual issue, and he's asking for a partial summary judgment on liability on that. She has listed in interrogatories 13 or 14 different drugs that she wants a declaration summary judgment on liability for. And we don't think that's appropriate at all because we have huge factual issues on that.
I accept that. So what you're saying is sometimes when cancer treatment is finished and they ring the bell and they declare somebody cancer-free, there are still drugs that they recommend they continue to take to keep reoccurrence. And you say the policy doesn't cover these things, but that it's only for treatment drugs. And it's debatable whether these are treatment drugs or preventive or what. That's what you're saying, correct?
Yes, I am saying that the policy provides coverage for drugs used in the treatment of cancer.
Yeah.
And if she doesn't have cancer, then the drugs can't be used for the treatment of cancer. And this is not like.
What would you say if the doctor says that it's necessary for you to take these drugs the rest of your life to prevent reoccurrence? You're saying that's not covered.
I would say that the policy has a definition of cancer, and that's leukemia or a malignant growth. And if it's not treating the cancer, there comes a point in time where you can't claim to be treating cancer when you haven't had cancer for whatever, 10 years, 15 years. At that point, it doesn't become reasonable to interpret a policy for treating cancer that was essentially cured over a decade ago. So we're working on that.
I would use the word cured. Yeah.
Yes, but we have documents now that we've seen that say she has annual checkups, cancer-free, disease-free.
Okay.
So the other thing I just wanted to raise is procedurally, because this is a summary judgment. He's filed this motion in the midst of discovery, right? We just took the husband's deposition this morning. We're taking Sarah Flowers' deposition tomorrow. We have.
I'm not going to give it, don't let that bother me, because I'm not going to do a summary judgment today. But I'm using this as an opportunity to educate myself about the thing. And I thought it was a good opportunity before we got to that point while you're doing discovery to kind of catch up
Right.
where you are. I see what your argument on that things are, but I will tell you that if it was me, and I won't say if it was you, but if it was me and I'd had cancer treatment and my doctor told me that I was cured and that sort of thing, and I looked at the people around me that had cancer treatment and how many of them had reoccurred, I wouldn't feel a great deal of confidence to stop taking some medication that they told me I needed to do to make me healthy. I don't think if you get to a jury that that's going to be accepted very well. Just tell you.
Understood.
Okay. Okay. You have anything you want to add?
No.
Do you have anything else? I will give you plenty of time because I know it's a long trip down here. It's a beautiful place to be this time of year. So. You have anything else you want to tell me about? We're not going to do the partial summary judgment today. I'll take that under advisement. How long do you think it's going to take for y'all to finish discovery of this case?
I think we could finish discovery within the next 90 days.
Yeah. Yeah. And I guess now that the cat is out of the bag, as they say about this continued medication not being cancer treatment, you'll probably want to take some more depositions on experts or something. Is that correct?
Your Honor, that part is not included anyway in my partial summary judgment.
Yeah, I know.
Because that would go to the causation and damages.
Right.
So for that reason, it was not included in my motion for partial summary judgment.
Yeah. I was just talking about how much longer it was going to take to take discovery.
Well, I would think the 90 days would be more than adequate.
Yeah.
At least on everything except the bad faith issues.
Yeah. You know, I'm still having a problem making the jump where if I have insurance and the insurance starts paying me, it would appear to me that the cost of these drugs and other costs were a measurement of what you're entitled to, since they weren't directly directed to be paid in compensation for those or to another provider. In other words, this amount of money that you get under the cancer, it's a supplemental policy that says it shouldn't be offset by any other insurance benefits you have, like if you have an Aflac or something like that, that wouldn't be offset. And it does have an offset provision, doesn't it?
It's not offset by any other insurance, no.
What would be the offset?
Well, for example, the Medicare exception that we've been talking about.
I
That's a
think, I
different
thought it
type
had a
of-
provision that it would not be offset by any other insurance policies yet. It's something.
There, when it was sold,
Yeah,
and we attached a brochure that they provided us from actually Commonwealth back in those days.
yeah.
That says that there would be no, and I forget the exact words, but no penalty for, or no offset for any private insurance.
Yeah, that's what I remembered
Now,
seeing.
that's not in the policy, but it's in the brochure
The puffing.
that they sell with. And our client's affidavit was, even though she doesn't really recall that particular document, she does very definitely recall that was one of the selling features, is why she kept the policy all these years.
Yeah,
Uh,
I thought I remembered something like that.
I think has a brochure or something. It's not clear that brochure was even used in the sale of this or that it's relates to this particular policy. But in any event, the policy doesn't offset anything. The policy pays for the expenses that are incurred. And it has a whole bunch of paragraphs of things that are covered, those types of expenses. And so the issue is, what is expenses incurred? And I did want to hit on, Mr. Carroll has cited a bunch of cases. He mentioned the Pedicini cases. Those cases are inapposite. Those cases are not the same as this cancer policy. Pedicini, for example, interpreted the word actual charges. So you have these whole actual charges cases. This is a policy that pays for expenses incurred. In the insuring clause on the very first page, it says this policy pays benefits equal to the expenses incurred. You go to the schedule of benefits. Here are the specified expenses. Each of those paragraphs, you have drug and medicines expense. And those are charges that are used in the treatment of cancer. So
you're saying if D paid these, they weren't incurred?
they have to be incurred.
Well, what does incurred mean?
Incurred, I'm glad you asked that, Your Honor. That brings me to another issue. Expense incurred are not ambiguous terms. And
Well, who's incurring the expense?
Incurred means to incur a legal liability to pay, and an expense is an outlay.
Okay, well,
Right.
who are you talking about incurring it? The insurer that has providing the Part D coverage or the cancer patient? Who's incurring it?
Either one, Your Honor. Either one, but it has to be an expense incurred. It has to be an actual legal liability that's being paid.
Well, what is the value of this cancer policy then? If you either elect or don't elect D, the only exposure that the insurance company has ever on this thing is about $200 a month. Is that right? How could they, what kind of exposure could they have to pay out on this policy?
So once you reach Medicare age, you need to make a decision whether to turn in this policy or not, right? If you elect Medicare, then your expenses, your medical health care costs will be paid by Medicare. So this policy is not mandatory. You don't need to keep this policy. And once you reach the Medicare, you know the policy has the Medicare exception. Now, Sarah Flowers had this policy for years. And you see from the papers, she recovered over almost $3.5 million on this policy, which again was above and beyond the cost of her actual health care. This is all extra money. Now, once she reaches Medicare age, she can turn the policy in. She doesn't need to keep it. That's her choice. And I think she's decided that she wants to try to keep it for this lawsuit.
Your Honor, he's just confirmed something that I have suspected all along. They sell these policies with the plan for people to turn them in, stop paying the premiums when they get to cancer age.
Well, the actuaries might figure that in too, Mr. Carroll.
I'm sure they have, although I've not been able to discover that yet. Even though I have made some efforts, quite a bit of efforts. But on the Medicare exception that they're relying on, it, like any other exception, is something they have the burden of proof on. When we took their corporate representative and asked her that very question of, well, how much is the Medicare? How much is payable by Medicare? She says it's speculative. And actually her then attorney suggested the answer, which he shouldn't have, but he did and she did. She adopted it. And the reason it's speculative, because even if you elect for Part D, it may or may not cover any particular drug, or it may only pay a little bit. So they have the burden of proof. And I expected if they were going to pursue this.
So if you had D in part and you kept the insurance policy, then you'd have to do a incurred cost by incurred cost analysis to see if it was covered or not covered. And they'd have, the cancer people, policy people would have to determine whether they covered it too. There'd be two decisions there, right?
Well, if I had taken a Part D policy that did not cover particularly this one really expensive medication she has to take, if it didn't cover it, they would still be on the hook, even under their theory.
So that's what you're talking about, speculation.
It's speculation.
Whether at a particular time, the drug formulary for Medicare Part D would or would not pay for a particular drug. And if it didn't pay for it, the cancer policy would have to pay for it. Do you agree with that?
I agree that if it was not payable under Medicare, then it would not be excluded by that exception.
But you don't agree you would necessarily pay for it because it wouldn't be medically necessary.
Well, it'd have to be used in the treatment of cancer. And we know that Procrit's not a cancer drug. So that's another issue, in fact.
Yeah,
We'll get to.
I got you.
So they have, in a motion for summary judgment that we have here, once I pointed out in the motion that their defense is speculative, then they have the burden to come forward on that particular issue with something to disavow her testimony, contradict her testimony, or some way prove their point. They absolutely did not do any of that in their response.
Okay, well, let me
What
ask you
Medicare
something.
would pay.
Let me ask you something. From the time they reduced the payments or changed what their position was, is it your position that they'd have to go through the medical records and payment after that to see what they would have been subject to paying under the cancer policy? Is that your position? I mean, you can't speculate either about what they might owe. They'd have to prove up exactly what was paid by Medicare and what wasn't paid by Medicare.
Well, we
And then
know-
they'd have to decide whether they would have covered it too.
We know that Medicare didn't pay any of it because she doesn't have Part D. But they would have to show what Part D would have paid. And that's giving them the benefit of the doubt.
Yeah.
And I'm not conceding that the Part D even enters into it. I think the court has asked all the right questions on that. But
It seems to be put you in a difficult situation where you have to choose to get into Part D and cut off your claims and cancer policy, or not choose it and get them cut off anyway. There's no choice there, is there? From their position.
from their position, there's no choice. But even if it's their job in a motion for summary judgment, because their own corporate designated witness, not just a random person out here. The person they designated under the rules as their corporate witness testifies it's speculative, then that is.
Okay, I'm not going to do it today, but let's say I gave you a partial summary judgment, then from that point forward, there would be a continuing obligation for you to allege what the payments would have been and someone to prove that Medicare would have paid this amount and the insurance policy would have to pay this amount. Would it be an ongoing obligation year by year as long as your client lived?
It would be an ongoing ongoing obligation to show under the, not the exception, dealing with Medicare,
Yeah.
but under the general provisions of the policy to show the relationship between the cancer and the treatment that she's receiving and what those bills are from the pharmacies. But the Medicare exception should go out on summary judgment because their witness has said it's speculative. And under the rules, Rule 56 of ours.
Well, the amount is speculative. The fact that there was some offset's not speculative. It's just the amount speculative.
No, what is payable under Medicare is, she said was speculative.
That's the amount that was paid under speculative. What they would have paid.
What they would have paid for these drugs.
Yeah.
Is speculative. Well, that's what they have to show under their exception. It's their burden of proof. And that's why it's speculative, because all these different policies out here are all different. And multiple, it's my understanding, multiple of those policies doesn't pay for the expensive drug.
Period. So the ones, the different policy you're talking about that your client could have purchased under Part D. Well, I wonder how you choose which one of them you're measured against if they didn't choose any.
That's why it's speculative, Judge. That's exactly why it's speculative. And that's what the witness more or less said.
Well, I think that's a true answer. If you don't know which policy they would have chosen, you can't hardly tell how much that policy would have covered.
And they have the burden of proof on it, so their exception fails.
Would you say that the person was choosing the policy would intentionally choose the policy that covered the least so they could recover more money?
I think they could do that. I think
you need a Washington accountant to figure that out.
But
do you have anything else you'd like to say?
No, just that I think that that's showing exactly why there are all kinds of issues of fact here, summary judgment at this point.
I'm not gonna give a summary to parts of summary judgment, but they're all, this is gonna be very difficult. Some of these things are gonna be questions of law at some point. And the questions that maybe we'll get down to some questions of fact, but I think a case like this could have a lot of implications. If Mr. Carroll prevailed and had a lot of implications on how this law, if it was upheld by the Court of Appeals, the Supreme Court in Kentucky, how it was applied in other places. I mean, it could be a huge sort of shift in what kind of payments are made, but I doubt if there are very many people that ever collected this much money on a cancer policy. I would like to see how many people have, because most people buy cancer policies or Aflac or these other things and don't ever make a dime.
Yeah, most of those policies just have the schedule of benefits, you get $200
That's
for this
right.
and et
That's
cetera.
right. That's right. And I guess that's the reason the insurance company was bought by somebody else that might help. Okay, well, thank y'all very much. And I'm going to take it under advisement. And if y'all will kind of keep me informed about how the discovery is going, I don't ever push a case. But if either one of you feel like that you're clogged up and the discovery's not moving, you can get a hold of me, and it won't be necessary. I'll do it, allow you to fill on something like that by Zoom if you want to, so you don't have to come down here. Mr. Kirk. A motion to quash. First motion to quash.
Oh, that's been withdrawn by them, Judge,
Okay.
and reissued, I think, under the appropriate rules.
Okay. Okay.
Thank you.
Thank y'all very much.
Thank you.
Safe journey home. Butler versus McIver is that next one?
Say about the guy.
You did say that.
Hi, Judge. Michael Guilfoyle.
Hello, how are you, sir?
I'm doing well.
Good to see you.
Good to see you. It's our motion, Judge, to set a trial date for almost 4 years into this divorce. And we've tried mediation, at least formal mediation twice, informal mediation once.
Who represents Mr. McIver?
Mr. Lavett, Ted Lavett.
I'm
I'm with you, Judge.
Turn the camera on.
Yes, sir.
Well, I'll say that again. Can you get somebody to turn the camera on too?
Yes, sir.
There you go, Ted. Good job.
I've got good help, Judge.
Yeah, you need it. So. Is that your thumb over the camera, Ted?
It is, Judge. It is, Judge.
Put it back, Ted.
Yeah.
Okay. Okay, Ted, they want to set a trial. Has all discovery been finished here?
Yes, sir.
Okay, now what I'd like to do rather than just have a round robin in the thing, I'd like for us to establish the issues, Ms. Payne, on what has to be tried.
Judge, it would just be property and debts. And so the property would include the marital home, my client's business building. There is a piece of land. There is equipment for the oil drilling business. There are the two businesses, McIver Realty and the oil business and the drilling business. And then there's a inflatables business. Those are the assets other than automobiles, et
Do
cetera.
you have some intermingling or do you have any kind of premarital investment in any of these properties?
There's no premarital investment except, I don't think there is even in the land. No, none.
But my client has premarital investments, Judge, in his oil equipment.
I think one piece of equipment, Judge, I do believe that's correct.
Well, what I'd like to do, and could do it right now, is let's go down through the list of marital assets that we're talking about. And so then when we go to trial, we can take proof on each one of those separately. So we won't meander around, you know, I'd like to take one piece and hear the testimony on both sides, the next piece, the testimony on both sides, the next piece, so I can have some order.
But I don't know if I have my list of assets and of equipment.
Do you have a list that you've exchanged during discovery?
Yes, Judge, we have, and then we've had interrogatories.
Have you accepted that list, Mr. Lavin, as to be correct?
Well, each of us have lists that we've swapped out, and I think I understand their position, and I hope that they understand mine.
Well, what's the difference? Is that one piece of oil and gas equipment the only difference between the two lists, or are there things that ought to be excluded? What I want to do is establish the list first. First arguments that we're going to have is what's on the list. And then we'll go down through the list and determine whether it's marital, non-marital, all the other things you apply.
I
So
have a detailed list, Judge, and I listed it to him in interrogatories. Some of the things he agreed that they still had, some of the things he did not agree. My client has photographs of when the parties separated all of the equipment that was at the property. You know, we don't have a way to trace whether it has been or not.
okay, well, we'll just go ahead and take testimony and both of them can use each one of your lists. And do you think we can do this in a day?
I hope so.
Yeah. Mr. Lavin, do you think you can do it in a day?
God, I hope so, Judge. Yeah, I believe so.
Judge,
It'd be better if you hope so, Judge God, so.
Yeah. Well, we've been at it for 4 years, Judge.
Hey, well, we're gonna end it here, okay? If everybody's got their calendar here.
Yep.
Judge, it might be helpful if we each list the property that we think in our pre-hearing, the pre-trial.
That's what I was trying to get everybody to do, you know.
I'm more than happy to.
Do you have a particular list that you wanted to rely upon, Ted?
I do.
Okay, well, will you forward that list and say, definitively, this is the list that I am relying upon? And, Ms. Gilmore Payne will do the same thing. Both of you will rely upon those lists. That way you won't have to agree on each other's lists. And when we go down and take the testimony, both of you be prepared. And the items will be limited to that list. And I'll give you 10 days from today to go over those lists to make sure you haven't omitted anything. Because it's easy when you go through a lot of lists to omit something. So 10 days from today, we'll get the list. And then let's look at your calendars. What about October the 13th?
That works for me, Judge.
How many witnesses you have?
Well, that, and also, Judge, we have appraisers. Each person got an appraiser of the property. Can't talk about settlement agreements, but I think we may be able to come to an agreement as to which type of number we're going to use that we would all present. I can't speak for Mr. Lavit, but I would hope we could instead of trotting these appraisers in here. We also had a
Okay,
business appraiser.
October the 13th. And I wanna hear this in Burkesville.
Okay.
Okay. It's closer for both of you.
And Judge, that sounds good. I'm free on that occasion. Would you give me, to transfer the list about, instead of 10 days, could you give me 20 days?
We could do ours in 10, Judge.
I'd rather you do, well, let's make it 15 days,
That's
okay?
fine.
15 days. I mean, you gotta have some time to prepare for what you're looking at. 9 o'clock,
That works.
9 o'clock central. And we'll go that day till we finish.
Thank you for the consideration of Burkesville. It's much easier for everybody.
And it's a beautiful drive over here too, so.
It is. Maybe.
Okay, Ted, get somebody to turn it off for you there, buddy.
Okay, thank you, Judge. Thank you.
Okay, the next case is Orton versus Orton. Okay, you've written this document here, and I really, Mr. Cross, you say the motion is defective, should be dismissed. What's your argument?
Well, Your Honor, you know, when it's just, you start at the top and you go through, there's no address, we have to track him down, you know, it's improper.
Let's talk about the motion itself. We're here.
Right. Let me advise the court where we are in this. We have today filed 3 petitions for involuntary termination for these 3 children. That has been done.
In this court?
Yes.
Okay.
So we think that ought to be addressed before anything else. And as we said in our response, 3 years is too long.
Well, there's some mention in you mentioned something about child support.
He's paying some support.
Well, child support is a separate issue.
Yes.
So we're not going to consider child support. It's a separate issue that has to be taken up because visitation and custody are not to be determined by whether somebody is paying child support or not, but that sort of thing. Now, what kind of and you've asked me to recuse predicated on some relationship, some family relationship I have with somebody?
Yes, sir. I know that you and my parents have ties.
What ties are they?
Like where y'all went to school in Burkesville with all my family. I mean, I think.
Well, I went to school with everybody in Burkesville.
I understand that, Your Honor. But I also know that I've been told by them that you'd be on their side. Just saying that was from them. I mean, just throw that out there. All I'm asking is for a fair shake, and I don't think I'm getting it here. Not just from you, I'm talking about from downstairs as well.
What's downstairs?
My brother-in-law, that, I mean, some of the things, like I say, I got charged with a.
John met the sheriff?
Yes.
Yeah. Well, I don't know about any kind of relationship.
I'm just asking Judge.
But I'm gonna tell you something about me and the sheriff. I didn't know the sheriff before he was elected. I heard who he was, but I didn't know it. And as far as any kind of special relationship, I think, yeah, Aunt Diane that was in my class. But I seen her 3 times in 40 or 50 years, a wonderful person. I guess I knew her dad and mom. But I don't have any family relationship. I've never had any business relationship. I don't feel like I'm going to recuse, and I don't think you've been treated unfairly. But I want to know exactly what you propose.
Your Honor, I'm just asking to see my kids.
Well,
I got a domestic.
give me some specific proposal, because you've had
My proposal-
these DVOs and all those other
Okay,
things.
I've never had any charges for domestic. She was given a 3-year DVO the day you signed on our divorce. With no charges against me, not one time have I ever been charged with a domestic violence order, ever. That's in the new petitions. You gave her the DVO standing here the day that you signed the divorce. I've never been charged with domestic. They can't even use that against me because I've never been charged with it. I have never touched one hair out of line on her head ever, or the kids or anyone else, and she knows that. To sit and say it's unreal would be lying under oath, and I'll take a polygraph. Will you? And I put in that petition that I signed, she would lay in bed, Your Honor, and I'm gonna say this, and say, if anything ever happens to us, I would never take your kids away from you. You're such a great father. She had a great life until I got hurt my back, had to have 3 back surgeries, and she finally had to get up and get a job. She had a great life, didn't get a lick for nothing. I kept everything going. And then she says, I'm not paying child support. Yeah,
But
it has
been child support off the table. We're not here to talk about child support.
Your Honor, I'm asking to spend time with my kids. That 3-year DVO that you gave her, turn my retainer fee from $500 to get a lawyer to $5,000 and up, because I have tried it. I have tried.
Tell me about the DVO. Yeah, give me your side of it.
We weren't really involved in that, Your Honor, at the time. It's just presumptive if the board entered, it's a domestic violence order. That's about all I can tell you.
It wasn't in this case, though.
Yes, it's our
Wait a second.
Yeah, but we weren't involved in that.
There was an EPO. There was an EPO.
It was converted. I think Ms. White. Yes.
Yeah, I didn't remember you being involved. How long does that last?
It should be over this coming year.
It was a 3-year. It just expired.
Yeah, it's expired already.
I believe it expired in May.
I thought it was for the following year until 2027.
It's expired.
And it was never against my children.
Wait a second, wait a second. Wait a second. You know that. We're just waiting for fire inspector.
Your Honor, can I say something? I'm sorry.
You'll be given the opportunity to say whatever you want to. Just let me look at this one.
Yeah.
Is it expired?
Yes, I'm sorry.
Okay, so there's no DVO.
May I further address the court, Your Honor?
About the DVO?
No, I'm sorry. About our situation. Go ahead.
Let me move it.
Your Honor, it had been Ms. Orton's initial hope that Mr. Orton would have a relationship with these 3 kids. They're all well up in age now.
How old are they?
I think the oldest is 14, 15, 11, and 8, is that about right? And Your Honor,
Or 12.
you go on, and at this point in time, after 3 years, Ms. Orton had determined to go on with her life and with the children's lives, and hoped that they could just proceed on with their life because they can't depend on Mr.
Well, okay, I don't want for you to say anything that will further inflame.
I don't want.
Wait, well, I say you to stop, okay? Stop. Here's the deal. There wasn't ever any allegations against him as far as, and that's the reason I looked at allegations as far as harming her. She was afraid of what he might do. She said this or that. But we're gonna try to give him some visitation of some sort. Now, the question is this: what kind of shape are the children in as far as wanting to visit? That's the next problem.
Your Honor.
And that's always gonna be a problem when they've been kept away from him all this time and probably hadn't had a lot of people taken up for him. Not that I don't know who he deserves being taken up for or not, but there hadn't been anybody giving him both sides of the story.
Right.
So I'm going to appoint a friend of the court. There was never a friend of the court. I'm going to appoint a friend of the court to get involved in this. This will be an experienced lawyer who will interview these children and see what sort of transitional sort of things and problems they might have. Now, y'all were the ones that decided to procreate with each other. The kids didn't decide that. I didn't decide that. But it is damaging to a child not to have some relationship with their father or mother, no matter how deserving or undeserving that they are, because there will be scars there that make them think that their parent abandoned them at some juncture. We want to avoid that and to stop the bleeding. Now, I don't know whether the termination of parental rights, that's a big hill to climb. Okay, so I'm not considering that for, so that's not one. So I'm going to appoint a friend of the court right now to immediately set up some interviews with the children and with each one of you. And we'll just see where we go from here as to what, and whether there needs to be some counseling for the children or I don't see ever being able to bring the two of you together for any parental counseling that your relationship might improve. Well, I think I know you will, but I some things can't be repaired. There was an old politician in Kentucky who said one time there's stumps that you got to plow around. Okay, so let's say that each one of you can pray for that you'll forgive each other and that sort of stuff, but I'm not going to go down. He said, she said, you said, well, I was lying in bed, you told me this. I'm not going to go down that route. I'm finished with that. So what we're doing is we're going to focus on his children. We're going to focus on the friend of the court, interviewing them and seeing what we can do to establish some kind of, but you've got to tone it down, man. You've been jacked up ever since I've known you. And the only way I know you is here, but some people are just wired like that.
It's just over the key.
Well, I understand you're wired like that. It's okay. I mean, some people are warriors, some people drive trucks, some people police officers, some people lawyers. And you've got to work on that because it does not help you when I see y'all wired up about this stuff, about what you might be capable of saying. I know you're hurt, and I have no doubt you love your children. Don't say anything. You want to say something all the time. It's sometimes being quiet is the best thing. Just suck it up because I don't know, there's nothing you can do to me. I'm at my age, I'm already on borrowed time right now. So, I'm not afraid of you and not anything, but I'm going to tell you, I don't have anything against you and I don't have anything against her. Mr. Cross, sometimes I've got things against him.
Feelings mutual.
Yeah, I know it's a mutual feeling, but we've tolerated each other for 70 years since we've known each other. If he called me in the middle of the night, I'd come to him and he'd come to me, and I'd feel that way about you, So we just need to ratchet it down. I'll get a friend of the court appointed the next few days. They'll be in contact. We can make sure the clerk's office has phone numbers. But I don't want anything that happens between now and then to change my mind. I want you to make sure, even though there's not a DVO in place, you leave this woman alone. And okay, maybe if you're going to, it'll be easy for you to leave her alone. But I'm just telling you, you leave her alone. She's not going to be around you. We'll let the children get interviewed. I don't want you or anybody in your family or anything saying anything about, this. I want a status quo order on this thing. And so we'll try to ration it down and get it where at least till the children are adults, then they can make their own decisions on what kind of relationships they want to get into. Okay? And can you draw an order up kind of that effect?
I will do so,
Send it to me, and be generous in the order, Mr. Collins.
Well, I will.
Generous to me.
Thank you, Ron.
Yeah.
Yes, but spread it according to the appropriate way.
Yeah, okay, thank y'all very much. So you can go out first and your family yeah, I'm gonna put it back on the docket for September the 10th.
Mr. Walton, are you still East Mount Vernon on Summer?
I give them that, and I changed that today. I done it. They should have had it on record.
Well, that's okay, just give the address.
I need address. Larry, have him write his address down.
Okay, thank y'all very much. Duval versus Abbott. Hello.
Thank you.
I've looked at this. Explain to me what this is about.
Well, I will, Your Honor, but I'll tell you up front. I think we've reached an accord with the assistance of the two surveyors.
Okay.
Uh,
So I don't need to know anything about this today. It gets
No,
redocumented.
we want a judgment entered today, but I'll tell you what, I do need to explain it to you so you'll understand how I think we should proceed. Ms. Abbott or someone on her behalf erected a fence over on property of Sloan, and it impeded the access of both Sloan and Tom Duval. And that didn't get taken down, so we filed suit. Mr. Talbot conducted a survey. After we filed this motion, I think Ms. Abbott had contacted Mr. Staton, and Mr. Talbot and Mr. Staton have furnished me with a new plat, which actually is more favorable to Ms. Abbott than the one we filed with our motion. They've moved the line over 13 feet. So what I'd like to do is obtain summary judgment today. And because she's not responded, I'm entitled to it, of course. I'd like to attach the amended plat and the summary judgment and then get that recorded downstairs where we get this thing over with. That's what we've been trying to do with for several
He
years.
represents Ms. Abbott.
She has no, I guess you would say Mr. Staton for lack of a better reference, Your Honor. That being said, the only other issue we have is the fence needs to come down. And I don't know if she's going to take it down. And if so.
You, Ms. Abbott, so you're good.
Come
with
around.
this? Is that, you know where the new line is and stuff? Are you good with this?
Yes, yeah. Greg came out and repositioned the lines and I've agreed to move the fence over.
Okay, well, that makes me feel better about it.
I think that's much better, and we're not seeking any money damages and never really did. We just wanted to get it resolved.
Okay, so you're satisfied with this?
Yes, I agreed to.
Okay, and make sure we show her the new, you got the new survey.
You've got the new plat, don't you?
I haven't received any paperwork.
Well, have you got one with you?
I've only got one.
Well, let her see it.
Yeah. This is the one that Greg did. It's dated August 5th, and it's moved that line. He said 13 feet. So this is the one.
15.
Maybe it's 15.
Yeah.
But this is the one we're going to go by. Is that okay?
Yeah.
Okay, well, let her, just give that to the clerk's office and we'll make you a copy.
Yeah.
So you'll have some certainty, because I want you to leave, I want you to leave here with
Let me
it.
know.
You know, I want you to leave here with it.
Huh.
I want you to leave here with it. Okay.
Yeah.
Okay, that's fine. We'll do that.
And you'll get a copy of what we're doing tomorrow.
Okay. Shoot, you can get the clerk's office, step over there, give you a copy of it. Okay. Taylor versus McGaugh.
Flowers now, Flowers versus McGaugh.
Taylor and McGowan, Taylor Flowers.
Your Honor, this is our motion regarding Mr. McGaugh.
Child support, huh?
And Your Honor, he's right now, the motion is self-explanatory. Mr. McGall is fortunate to have a good job. He works out of town. He's in a position to pay support, and these people have 4 kids. He's paying way under the guidelines, although he is furnishing
How
insurance.
much behind you say he is?
How much behind?
1,500.
1550 plus on childcare, he's 1455. So he's.
I mean, I was interested in childcare. How do you determine the amount of childcare? Is it a blank check?
Well, we've got.
No, I'm not asking what receipts you got. Who decides what the childcare costs?
He's the primary custodian.
Well, I know, but I mean, you can't just allow somebody just to, like, I mean, how many days do they need the
I have to
childcare?
defer to her on that.
Well, I know, but it won't ever work that way when you got somebody, one person. That's just like saying, I'm gonna pay you $150 an hour, but you determine how many hours you're gonna work. We'll be here all the time in a disagreement. So,
Well, I could put her under oath, Your Honor, if you'd like to hear from her.
well, I'm just talking about a continuing process. I'm not disparaging this woman. I don't know this woman. But when does she need childcare? Do you work outside the home? Where do you work?
Come up here.
I currently work at Twin Lakes Rod and Custom.
At what?
Twin Lakes Rod and Custom. I do the secretary work there.
What is Twin Lakes?
It's like a mechanic shop.
Mechanic shop.
Yeah.
And who does the childcare for you?
Her name is Paula Gross. She keeps them like in her home
In her home?
Mhm.
And so she only keeps them when you're working,
when I work, when they're with me, yes.
when they're with you and when you're working.
Mhm.
Okay. And how many hours a week is that each?
It's between 32 and 38.
Okay. And so you work that much every week.
Mhm.
Okay.
And so,
And how much an hour do you pay her?
do I pay her? It's $15 a day
$15 a day.
for each kid. Yeah, for each kid. So
So-
$30. Only 2 of them go to the babysitter. So it's $30 a day.
Okay, and sir, when you have the children in any of your working hours or anything?
She has them 3 days, I have.
Okay.
Here recently, my mom's gonna keep one. She kept them 2 days this week and, her mom kept them a day this week. I talked to the babysitter yesterday,
Yeah.
Paula, but Taylor knows, before we was here last time, Chelsea, my woman has kept the kids. It don't cost nobody no money, nothing, but she attend to quit letting her watch them. Because just being spiteful at everything, just like I told Paul, I said, I mean, Chelsea was keeping them. but
So she was keeping them days when you're.
Yes, I mean, all she gotta do is call and come pick them
Well,
up.
I understand what you're saying. So what you're saying is that you have childcare available that would cost neither one of you anything, but she prefers to use someone that's $30 a day.
May I address that? Your
Yeah.
Honor? Your Honor.
Okay.
Mr. McGall gets the children half the time while he's here. Okay, so if he is in town and his woman, significant other, whatever, can keep them, that's one thing. But if he's working hundreds of miles out of town, this is a woman that is not married to him and.
No, she's married to.
No, wait,
Oh,
wait,
no,
wait a second. Congratulations.
Good,
Thank you.
okay. That what you refer to as your woman, that wasn't your wife, so, okay.
Well, I mean, that's a good
But
thing. You
in any-
acknowledge, at least we acknowledge that there are two genders here. We're all in accord with that. And a lot of courts not accept it.
But if he's there, there's no issue with her keeping them. But if he's not there and he leaves for extended periods because you've got to leave Clinton County to make good money and that's what he
How
does.
old are the children?
They're, our oldest two were 8, are not twins. Our oldest would be 9, but 8, 5, and 3.
8, 5, and 30. So you got 4.
Yeah, 4. So.
Okay, well, I guess we can take some testimony at some juncture as to whether his wife is a fit and appropriate place to have the children if he's not there.
And that's
Wait,
what.
just don't wait a second. I mean, I've been pretty liberal now, but I want to try to keep things from escalating. You know what I'm saying? Will you step out and see if your client has specific objection to the new, now that they're married, that sort of thing, if she has an objection for when it's his time with the children. His wife keeps the children, babysits, just during the hours that she's working.
While he's here.
No, while he's gone, it doesn't matter to me while he's here. Gone.
Yeah, I'll have to talk to her about that.
Yeah, I mean, if it's his time.
Well, Your Honor, but here's the thing about it, it's not his time. His only time is when
I thought
he's
you
here.
said 50-50.
When he's here.
Why, does it say that in there 50-50
Yes,
when it's here? Does
yes,
it say
because-
50? Does it say 50-50 or 50-50 when he's here?
It's 50-50 when he is in Clinton County, because otherwise he's hundreds of miles away.
Well, I don't care. I'm not talking about what the document says. Look at the decree document and see if it's not 50.
It's his only parenting time is when he is in Clinton
I
County.
want to see the document. I've said that. Let me look at the document. Notice on the face when we look at the.
Your Honor, it's the agreed order is in the file that was entered last month.
Where's in there? Wait a second. So as long as he's in Clinton County, what does that mean?
Your Honor,
Yeah, does that mean as long as he lives in Clinton County or while he's out on the work?
Your Honor, these people, I represent Taylor in the divorce. Mr. McGall, she's been very respectful of his work schedule and he can be a good provider. This is what he agreed to, is he wanted the children when he was here. That's what we've agreed to do. We've tweaked it a little last month because there were some issues, but we've got an agreed order. When he is not working and comes to Clinton County and he's here at his home, he's got to have time.
And that's been, I think, my understanding is correct, that's been the agreement.
I'm sorry.
That's been the agreement since the beginning. It was just in the original decree.
Yep.
There was some, it wasn't very particular. There's an issue
So we
regarding
tweaked it
notice.
last month,
So
yes.
we did this last month.
To clarify.
To clarify. There were some issues regarding notice of when he would be implemented.
Now, is he paying 50% of the child care when she uses child care? Is that what it is?
Your Honor, he's only paying $500.
No, I'm talking about.
No, he's paying all the child care.
Paid none of the child.
No,
Well,
he's supposed to pay all. Supposed to pay all, right?
In the agreement, it said that he would reimburse me
Reimbursed.
for the child care.
Wait a second, please.
There a separate settlement agreement.
Your Honor, I don't know what the guidelines would be on Mr. McGall, but they'd be at least 3 times what they are now. So
It wasn't addressed. That would have been in March.
You have a separation agreement to file.
I do. Looking for page one.
I'm saying about the child.
Okay. I mean, everything's agreed to. We're just trying to do what we can.
Mr. Cross. In this, Mr. Cross, we can't find anything about childcare.
Well, Your Honor, it's in the agreed order that was entered back in I believe March of this year.
It says there. The respondent agrees to reimburse the petitioner all child care costs expenses regarding all children. Petitioner shall send a statement of amount owed to us by the end of each month within 14 days receive the same reimbursement. That's what you want. Can you agree to that?
Yeah, Your Honor, I mean, I agree to everything. I mean, I give her all the kids.
Well, I
because-
know, but only thing I can't reopen these things. I'm just looking at what's the agreement.
Yeah, I mean, and that's what I was saying.
Okay, now when are you gonna pay this?
Well, that was the problem. I've not been able to return back to work because every time I leave to work, she runs and gets an EDO. And if I get back inside and then she does it because that's what she wants to do, is costing my job.
Well, okay.
And then.
Okay, I'm aware of that now. That's not gonna happen.
And then,
when you gonna pay the money?
well, I mean, that's the thing. I mean, mine and her agreement was, and I mean, I
It
know
doesn't matter what your agreement is. What, I'm going on what the order says.
when I get back to work,
Okay, when is that?
whenever I quit having a court every
No,
month.
no, when can you get back to work? You're not gonna have to work anymore, okay? When can you make?
I'll have to call. I mean, because I mean, they kind of like put me on the side burner because I've been having court every other,
Well, okay, so,
and I'll have to call.
yeah, how much is he owed?
total of $3,050, I believe.
Yeah, and that would be the child support payments, which are very small. Child support payments are below the guidelines. Sometimes I wonder how people meet the guidelines, and live themselves sometimes, you know what I mean? But you're below the guidelines, but even if you put this childcare together, it's probably not much more than the guideline would be.
Yeah, I pay for child support now on where it lives with me. I mean, child support ain't my problem. What my problem is these other loans when we got a divorce, because she didn't have the credit.
But here's the thing about it is I can only go by the orders. Okay. I can only go by the orders.
Yeah, I mean,
Your Honor, we don't, Tyler doesn't want to be overly hard on Mr. McGall,
Well-
because when he works, he makes good money.
Okay, well, let's set up a payment schedule. You suggest a payment
We just
schedule.
want to get him on a program.
Well, give me a payment schedule.
If he's $3,000 behind, could he pay $1,000?
Let's make it let's make it $500 extra a month to get it called.
Whenever I turn back to work, I'm depending on when they let me go back.
But if you can't go back to work there, you're gonna need to get work somewhere, even if you're not making as much, okay?
We have no intention of filing
You don't
anything
need-
else.
you-
Let's get on a program.
Here's what I'm gonna do. I'm gonna give you a month and a day to make the extra extra $500 payment, along with the other payments you got to make. And you come back, you don't have to come back here on September 10th. If you made your regular payments plus 500, and you paid 500 a month for the next 6 months, okay, so you pay the regular payment.
I want to inquire of Mr. McGall, because of the way his work is set up, you know, it's not a wage assignment. We're not paying it through the child support office. Are you fine with sending her the money? Would you?
David, to be honest, I got a lawyer in the way that you've done me so far. I don't even talk to him.
Okay, well, let's let him make it payment to the clerk's office.
Okay, that's fine.
I think that he's just, that way he's got a receipt
That's fine.
that he knows.
Just trying to
where the
accommodate
payment
him.
is, and when he comes back in here, you can say, well, check with the clerk's office. So you make your regular payments that you agree to, and then $500, 30 months, a month from today, and $500 there until you catch up. And if you're caught up, you don't have to come back to court any more times. Okay? You know, there's no reason for you to contact her about anything. How are y'all communicating with each other?
We do fine, Judge. I mean, the only thing like I ask is like drop off. And then I can get work, but like drop off, she makes a point to make me.
But I don't wanna.
To make me be there. Will I have to be the one that Chelsea can't go pick up the kids?
He is in the young.
But see, and that's what I'm saying. So the whole time I'm.
He's not gonna pick the kids up.
If he's.
But see, if I'm on the road.
Wait. I mean, he's not gonna be getting the kids unless he's in the
That's
county.
right. If you're on the way in or on the road, that's fine to have her.
Okay, that's good.
Okay.
But, so we're saying that the whole time I'm going on the road, I can't never get my kids.
That's what
You won't, that's what the
No,
agreement
you
says.
said 50-50 now, that's why.
No, that's not what the agreement says.
Oh.
It says when you're in the county. It says when you're in the county. Now, whether you should
I
assign.
wouldn't marry you.
Well, I don't, things have changed. But there's no motion to there's no motion to modify that right now. I've got to go by the order that's placed. If you want to now that you're married, if you want to modify that, you can file a motion and modify, or they can modify it by agreement. But today I'm bound by what you agreed to. So I'm not going to try to put you in jail or make you pay $3,000 or anything like that. You make your normal payments, 500, the first 500 a month and day, 500 every month you catch up. And then when you're in the county or on the way back into the county, we'll be here shortly, your wife. And I would encourage you, if you wanted to remain your wife, that you don't call her your woman, you call her your wife. It's a personal experience.
It's just a lot been going on.
Right, you won't be called a wife because you are the wife.
Correct.
Okay, well, you are the wife. So.
Your Honor, one final thing.
Yeah.
He was $3,000 behind. She has to pay me to come up there, and I've asked for.
I'm not gonna give you the attorney.
Well,
Not
I was
yet.
afraid you'd say that.
Yeah,
You know, it's really
I'm not
fair to
going,
her.
I'm not going yet, but if this is not complied with, I will take under advisement today the attorney's fees that she incurs. And if I have to come back, then I'll pile on the attorney's fees.
We hope we're not back here. We don't want to come back.
Believe me, I do too. And everybody hopes we're not back here. Okay? Thank y'all very much.
I'll change it over.
You have a good, make sure we have a good address so you can get a copy of the order, okay?
We've got your address. He owns property.
Step over the clerk's office. Okay, get you a good address, okay? Now, I hope you get your job back. I hope you get your job back. It's working, okay?
No, I just didn't want to come back to work.
Okay, thank you very much. Okay, what's the next? Mitchell case. Mitchell case. Cody Mitchell versus Samantha Mitchell.
Good afternoon, Judge.
This one you said.
Is that your?
No, it's not.
Okay, never mind.
We had the schedule for a hearing in Cumberland County. I believe.
Okay. Okay, what issues do we have to be heard on?
This will be the visitation, custody, and then we had a hearing and we got it rescheduled, and then poor Burkesville had the flood in the courthouse on that day. So I'm assuming and hoping that that's all cleaned up. We just need a new date.
We're focusing. That day. I'm going to review the speaking.
I don't have a one we thought was.
There's another.
The issue that I'm just realizing is that we need more language.
And we have the friend of the court, Paragon, I believe.
Yeah, let's go off the record just a second. We'll
Yes,
be-
sir.
Yes. Stay off the schedule. We just realized that we have a scheduling glitch on another case we scheduled today. We're used to having two courtrooms, and we just have one courtroom there. We scheduled something on Wednesday. Yeah, we just found one that was scheduled on Wednesday.
Oh, no problem.
So.
I'm glad you got it.
Let's do it on 6. What day we got to go?
That's up.
We'll just get to something. 13.
That's what we said.
It's okay. So you make this one on the 14th. Let's start it. Start this.
That one's scheduled to be months.
Okay, let's look at the 14th.
Of October.
October 14th.
October.
At 1 o'clock.
We're available, Judge.
And it'll be here in Clinton.
Here in Clinton County. Okay, if there's any additional lists or that need to be exchanged, what are the issues that we're going to decide, Mason? What do you want me to decide on?
Well, Judge, the main issue is just the pending motion to have my client re-engage with his children. It's been ongoing for
No, that's the issue. There are no other issues there, right?
That's it, yeah.
Okay, how many witnesses you anticipate you'll have?
I anticipate 3 and probably some substantial cross on their custodial expert and possibly the friend of the court.
Okay, we'll start at 1 o'clock and we'll go till we finish. Okay,
Thank you, Your Honor.
thank y'all very much.
Have a good day. Would you like me to do an order setting that?
Right, be wonderful. I appreciate it.
Okay.
That was wonderful. Thank you.
Yes, sir. Have a good day.
Okay, thank y'all very much.